this was when, just my lord, by way of information, Narasimha Rao ji was the Prime Minister and Dr. Manmohan Singh was the Finance Minister. They pioneered, my lord, this new industrial policy. But please come to para 7. I'll read only relevant part, my lord. Page 385, my lord.
Which volume 3?
4G.
4G.
Roman 4,
4G,
capital
okay.
G.
Is there a E?
Why this act is still relevant? Why it is consciously not either amended or repealed? And why it would be necessary, my lord, for your lordships to examine it in that context, that in future, even present, it is implemented and it needs to be implemented, maybe, my lord, depending upon the circumstances. But para 3 to 6, earlier policies are dealt with. I am not, my lord, taking your lordships. Para 7 of, my lord, this is industrial policy dated July 1991. Para 7, the policies created a climate for rapid industrial growth in the country. That is earlier policies. Thus, on the eve of the 7th five-year plan, a broad-based infrastructure had been built up. Basic industries had been established. A high degree of self-reliance in a large number of items, raw materials, intermediaries, intermediates, finished goods had been achieved. New growth centers of industrial activity has emerged and has new generation of entrepreneurs. A large number of engineers, technicians, and skilled workers had also been trained. Now, my lords, may kindly, my lord, see the next page. Lord, it demarcates in 4 categories, my lord. In para 19, my lord. In pursuit of the above objective, the government has decided to take a series of initiatives in respect of policies relating to the following areas: industrial licensing, foreign investment, foreign technology agreements, public sector policy, MRTPA. My lord, we are concerned with the first only, my lord. Please see, my lord, industrial licensing policy. Industrial licensing policy, licensing is governed by the Industries Development and Regulation Act 1951. The Industrial Policy Resolution of 1956 identified the following 3 categories of industries: those that would be reserved for development in public sector, those that would be permitted for development through private enterprise with or without state participation, and those in which investment initiatives would ordinarily emanate from private entrepreneurs. Over the years, keeping in view the changing industrial score seen in the country, the policy has undergone modifications. Industrial licensing policy and procedures have also been liberalized from time to time. A full realization of the industrial potential of the country calls for continuation of the process of change. Not para 22 thereafter, your lordships may skip 21. The winds of change have been with us for some time. The industrial licensing system has been gradually moving away from concept of capacity licensing. The system of reservation for public sector undertaking has been evolving towards an ethos of greater flexibility, and private sector enterprise had been gradually allowed to enter into many of these areas of a case of caste basis. On case-to-case basis. Further, impetus must be provided to these changes, which alone can push this country towards the attainment of its entrepreneurial and industrial potential. This called for bold and imaginative decisions designed to remove restraints on capacity creation, while at the same time ensuring the overriding national interests are not jeopardized. Thereafter, your lordships may kindly come to Lord para 39, my lord. Page 389. My lord, I am skipping what is not relevant for the IRDA purpose, because they made several changes in foreign direct investment, etc., etc. And MRTP Act was, mark one thing, MRTP Act was substantially amended to bring it in tune with the new regime of liberalization. Why I say this, the government thereafter consciously neither repealed the IDRA nor amended IDRA. And I'll point out, my lord, why.
But Solicitor, you are relying upon this 1991 today. So it looks very primitive. And so much has changed now. Today, you are relying upon 91 policy.
I'm not relying upon. I'm sorry. I'm not relying upon.
Right.
I am. This can't be relied
To
upon.
respond to what Honorable Chief Justice of India said, I mean, this policy in today's context.
Kindly allow me.
Right.
I am not justifying the act based on this policy. It's a 91 policy, years back. My purpose is to show that the changes, winds of change, as they say, is taken note of. There are certain changes made. The IRDA is taken note of. Well, this is the policy which delicensed everything except some items. I am not saying that I justify IRDA. I am not supposed to justify because that's not under challenge, but that's a very basic argument. I am just saying that this was, my lord, a event which changed the course of our economic history. But still, IRDA was neither amended nor repealed. And, my lord, after at the end of this, my lord, I'll be able to show why I am showing this, my lord. Not to rely upon it, to justify existence of IRDA, to point out to your lordships that it is still in operation and in future it can still be required to be utilized by the country, and therefore consciously it was not done. As my lord the Chief Justice of India, my lord, was pleased to say that now we are in a delicensed era. That is true. From 91, we are in a delicensed era. And the provisions which I read provided for licensing. But some scheduled industries are still under licensing regime. And I will be able to show in future, if the circumstances or contingencies so demand, the country may need again to control them. And I will give the illustrations, my lord. Lord, para 39, decisions of the government. Lord, kindly see A, industrial licensing policy. Industrial licensing will be abolished for all projects except for a short list of industries related to security and strategic concerns, social reasons, hazardous chemicals, and overriding environmental reasons, and items of elitist consumption, that is list at Annexure 2. Your Lordships need not go it right now because that also has kept on being amended. I'll point out what remains in the schedule as on date, my lords. Now, your Lordships, my lord, kindly turn to Annexure 2, my lord, just to have a flavor, my lord. 392, my lord. Since, my lord, this case incidentally concerns alcohol, but as I have pointed out, my effort, my lord, is not Lord, let me, my lord, make this again clear. Lord, my effort is not to succeed in case of alcohol. That alcohol only center has the power under entry 52. Lord, entry 52 encompasses several things. And therefore, my lord, your lordships in this combination are examining the question of law. Therefore, my lord, must point out from a broader perspective than just alcohol. Because that happens to be the case here, the fact situation, but your lordship's law would apply across all industries. Lord, distillation and brewing of alcohol was still under the licensing regime. Now it is not, my lord, I must say, but it was, my lord, at the relevant point of time. Now your lordships may kindly see what is the present position. List Annexure 2 constantly became shrinking. It remains shrinking. My lord, more and
Where
more.
will we get the latest position, Solicitor?
Yes, my lord, we have uploaded it, but it has not reached your lordships.
Okay.
My lord,
Won't
it's,
be-
it's only one page.
It will not be in this act.
It's not in this act. My lord, it's one page. My lord, if I can request
Yes, certainly.
4I. 4I, page 23. Now the act, my lord, controls, regulates, or provides for licensing of these products as on date.
4I.
Lord, for my lord, only completing the record, section 29 capital B of IDRA provides or empowers the central government to exempt certain industries. Your lordship need not go into
29B.
29 capital B, under which, my lord, several industries were, my lord, removed from list schedule 2.
Oh, I see.
My lord, the effect of 29B is it remains in the schedule to the act, meaning thereby it can always be brought under regulation. But for the time being, it would be exempted from the provisions or the regime or the licensing policies, etc., under the IDRA. So potential regulation remains. So, the lordships have not page 23. I'm sorry. It would be here, my lord. My apologies, my lord. It would be displayed, my lord.
Yeah, we got it. It's now there's a press note number 3.
Yes, 3, my lord. The press note number 17 series regarding environmental clearance of industrial license conditions of letter of intent industrial license relates to pre-1991 period. After the industrial policy resolution 91 and considering various amendments made to notification number so and so, only the following 4 industries are covered under the compulsory licenses: cigars and cigarettes of tobacco and manufactured tobacco substitutes, electronic, aerospace and defense equipment, industrial explosives, and hazardous chemicals. These are, Lord, now under licensing regime. The entire act applies to them. The rest of the industries are, as on date, out of it. But kindly bear one factor in mind. 91 policy delicensed everything. Thereafter, my lord, except for the rest of the industries were exempted from the licensing regime. But they continued in the schedule very consciously.
Schedule is not amended.
Not amended. MRTP Act, my lord, there is a discussion, my lord, in 1991 policy itself, that now we will have to bring it in tune with this liberalized regime. We also amend the MRTP Act, but this act is not even amended. And there is a reason why.
So, Colonel Solicitor, you are trying to say that following the liberalization regime that we entered into from the license charge, the government of India is consciously taking certain steps. And the press note that you are pointing out is that only now these 4 categories of industries are within the license charge.
Correct.
But we are keeping the industries mentioned in the schedule to the act, so that at a given moment, if we have to do something, we'll bring them within. But then the context, if you look at also 20B, which is the empowering, there also you have to do it on the exigencies or the contingencies that are mentioned in 29B.
No, my lord, kindly, I also, my lord, your lordships are right. My lord, I also initially read it like it, and that may be a correct reading, but thereafter, my lord, I changed my interpretation. My lord, that is only for one category. Please,
Yes.
my lord, read 29B.
Yes.
If the central government is of the opinion, having regard to the smallness of the number of workers employed or to the amount invested in any industrial undertaking or to the desirability of encouraging small undertakings generally. Well, this is first part.
Yes.
Or to the stage of development of any scheduled industry. This is second part which applies to the first three contingencies are for small industries. For other scheduled industries, stage of development of the scheduled industry that it would not be in public interest to apply all or any of the provisions of this act thereto, it may by notification in the official gazette exempt subject to such conditions as it may think fit to impose, etc., etc. So, my lord, first three is for small industries. Rest is, for example, non-potable alcohol is still in the schedule. My lord. No, nobody disputes that
It's
fact.
not regulated by the act.
It's not regulated by the act, my lord. As it stands today, it's not regulated by the act. So we have a particular quantity of non-potable alcohol which is produced. Now, non-potable alcohol has several uses. I'm just giving a hypothetical example why the act still retains the power to regulate in future. It goes into making of the potable alcohol. It goes into making of certain medicinal preparations. It goes into making of certain paints and other industrial uses, my lord. Now, my lord, we had COVID, for example. And we required, and the government of India, the nation requires that entire quantity of industrial alcohol should be used only for manufacturing sanitizers, for example, giving a hypothetical example. Then the government can again utilize the regulatory power. Therefore, the power is retained, the regime of forbearance is enforced, that we will forbear from exercising. But the power is there, and not a decision not to exercise the power is also a decision. But I have given two examples in my original note, my lord, if your lordships can come to 2D, my original note, just to, my lord, illustrate this point. Page 56 of my note, my lord, volume 4D, 2D, I'm sorry, my volume 2D. These are the figures taken from the Niti Aayog roadmap. Niti Aayog conducts that what is the requirement of the country qua each schedule industry, product of each schedule industry, whether that requirement is met, if not met, what steps are to be taken. Everything, since decades, everything happens very scientifically. There is a system in place. The country, doesn't run on an ad hoc basis. There are systems, there are institutions, every institution functions, they have their own defined roles, etc. Please see, page 55 first. What is the position of alcohol? This is what the Niti Aayog would examine. Your lordship have the chart, just I'm illustrating, this is by way of an illustration. 21-22, the ethanol requirement, my lord, for blending was 437 crores. I could have 50. For, my lord, page 55, 2D, volume 2D. For blending, requirement was 437 crores. And for other uses, that is potable, my lord, making beverages plus industrial alcohol, it was 270 crore liters. So the total requirement was 707. The country was meeting with that requirement, therefore regulation was not necessary. But suddenly suppose there is a spike in the use of alcohol. not potable alcohol, my lord, for use of any other alcohol, then possibly, my lord, the central government can step in and say that now we will control what will be produced, license will have to be required, from where you will procure the raw material. The raw material also may be required to be diverted. That sugar cane becomes molasses and molasses becomes ultimately the alcohol. So sugar cane would not be diverted for manufacturing sugar. It should be used for only manufacturing alcohol in a given set of circumstances. Therefore, the law is live. Right now exempting most of the items. My lord, similarly, my lord, please come to the next page, my lord. My lord, this is regarding the sugar. The sugar is an essential element, as essential food item, my lord. Please see, my lord, sugar cane production vis-a-vis sugar production and sugar consumption. So kindly, my lord, have a look at page 56. My lord, sugar cane production is this is in lakhs metric ton. In 1819, sugar cane production is 4054. Now, sugar is produced is 332 metric ton, lakhs metric ton, and the consumption is less than this. Now, suppose, my lord, for whatever reasons, international reasons or national reasons or whatever reasons, there is sudden decrease in the sugar production, and the nation needs uniform availability of sugar at uniform prices, then, my lord, sugar remains in the schedule right now under the forbearance regime. This can be true, my lord, about every product. Just to give an example, my lord, in case of, my lord, say defense industry, one of the scheduled industries. So suddenly the defense equipments manufacturing demand rises for any international reason, my lord. There may be some minerals which are which go into the manufacturing of the explosive or something. I'm giving a very, very broad and hypothetical example. Then the government can step in. Right now, you do without licensing, free market, free economy, no licensing. You do whatever you want to do. You invest your money, let the country grow, let the economy grow. But in certain circumstances, you have to step in. That is.
Then in regard to industrial alcohol, is the government exercising its regulatory power?
Yes.
Today, the compulsory licensing for industrial alcohol is gone. All alcohol is gone.
There are some regulatory controls. Licensing is not required, but I will show, there are some regulatory controls. The reason is this. Reason is
fair enough. Now you were actually last time when we stopped, you were looking at our the statutory provisions. So you showed us section 10.
Before that, my lord, would your lordship,
let's quickly run through the statutory provisions so we can make some headway then.
And my lord, I'll show, my lord, what. Lord, there is a biofuel policy, and ethanol is an element in the biofuel policy. It's a national project. Well, and if that project succeeds, my lord, the dependence on other fuel would be substantially reduced. So, my lord, there is some kind of a regulation in national interest, my lord. Now, please see, my lord, my lord, I'll take your lordship, my lord, to the notice. It's there, part of my original written submissions, my lord. But, my lord, before, as my lords have, my lord, been pleased to say, my lord, I'll just take your lordships to the act. Lordship, may give me only a minute. Your Lordship, I was at section 11. I'll read only those sections which are relevant. My lord, first, kindly see section 10. And bear, my lord, one fact in mind, your lordships are not deciding only alcohol. That incidentally happens to be the fact of a case which is referred. This law which my lords in this 9-judge combination would lay down, will apply to all scheduled industries today and in future also if regulation is required. Therefore, my lord, I am assisting not, my lord, to win in an alcohol related matter, to assist your lordships fully, objectively. Lord, section 10(3). subsection 3. Where an industrial undertaking is registered under this section, there shall be issued to the owner of the undertaking of or the central government, as the case may be, a certificate of registration containing the productive capacity. Well, production comes here. That's the reason I am not showing. Productive capacity of the industrial undertaking and such other particulars. Not four last two lines also. Productive capacity of the industrial undertaking and other prescribed particulars. Lord, suppose some commodity from the schedule industry is now brought under licensing regime for some good reason, my lord, subject to your lordship's judicial review if challenged. Then, my lord, this will be done. Then 5. In specifying the productive capacity in any certificate of registration issued under subsection 3, the central government shall take into consideration the productive or installed capacity of the industrial undertaking as specified in the application for registration made under subsection 1, the level of production immediately before the date on which the application for registration was made under subsection 1, the level of highest annual production during the 3 years immediately, etc., etc. So, production is a part of IRDA.
Yes.
Which undisputably traces its origin to entry 52, list 1, read with entry 33, list 3. Lord, why I say this? Tikaramji says industry in 52 is confined only to manufacturing. After taking note of the act itself, I'll show how Tikaramji is either bad or is obiter.
Now, apart from 10.3 and 10.5, what is the other provision?
11.2. I have marked my copy. I will not read anything which is irrelevant.
Right.
11.2. A license or permission under subsection 1 may contain such conditions, including in particular conditions as to the location of the undertaking and the minimum standards in respect of size to be provided therein, as the central government may deem fit to impose in accordance with rules. In future, this contingency might arise with regard to some of the schedule industries. Therefore, this provision. Then 11A, your lordships have seen license for producing or manufacturing new articles. But please see, my lord, 11B, power of central government to specify, my lord, I'm sorry, my lord, one more fact. While going through this, my lord, kindly bear one fact in mind, because that would be necessary when I assist your lordships on the question of repugnancy between the state provision and the central provision. Lord, one of the condition, one of the ground on which your lordship would test repugnancy would be that is the central act intending to cover the entire field of the subject? If the entire field is occupied by the central law, that would be one of the considerations. My lord, the Chief Justice in forum has, my lord, analyzed that. And my lord, I'll cite that judgment and one or two judgment on that. So that is one more reason why your lordships may see this act in totality, that it intends to occupy the entire field. They may use it, they may not use it. Then 11B, power of the central government to specify the requirements which shall be complied with by small-scale industries, industrial undertakings. My lord, this is what my lord Justice Roy, my lord, was my lord, saying 29B. Small industries, those three conditions. My lord. Rest, my lord, A, promoting in a harmonious manner the industrial economy of the country and easing the problem of unemployment. Then B, securing that the ownership and control of material resources of the community are so distributed as best to subserve the common good. My lord, in some contingency in future, like COVID, this power may have to be invoked. That includes, my lord, control over the raw material also, because that's one of the natural resource or natural, my lord, ownership of the nation as a whole. I may be, my lord, producing, but ultimately it has to be harmoniously and uniformly distributed for the advantage of everyone. Then, my lord, kindly see subsection 2D. The nature, it covers every, I'm sorry.
Yes, sorry.
It covers every aspect of industry. 2D. 11B, subsection 2, subclause D. The nature, cost, and quality of the product of the industrial undertaking. This is also controlled.
This is in regard to small scale industry.
Yes, ma'am. I'm just saying that the
All right, what apart from this, what else?
my lord, 13D. Further provision for licensing of industrial undertaking in special cases, effect any substantial expansion of an industrial undertaking which has been registered, etc. My lord, please see the explanation. Substantial explanation. Substantial expansion means the expansion of an existing industrial undertaking which substantially increases the productive capacity of the undertaking or which is of such a nature as to amount virtually to a new industrial undertaking but does not include any such expansion as in normal undertaking having regard to its nature, etc. The government in a fact situation can say, expand your industry, expand your manufacturing capacity. The way what we did in oxygen. Now, my lord, 15. This is, my lord, again to show that the entire spectrum of every part of industrial activity is occupied by the central law, which is completely missed by Tikaramji judgment. Power to cause investigation to be made into scheduled industries or industrial undertakings, where the central government is of the opinion that A1, there has been or likely to be substantial fall in the volume of production in respect of any article or class of articles relatable to that industry. So please, not just the product. When I say sugar, sugar cane, which is the raw material, is also relatable to the industry. Production in respect of any article or class of articles relatable to that industry or manufactured or produced in the industrial undertaking or undertakings, as the case may be, for which, having regard to the economic conditions prevailing, there is no justification. But the government can invoke 15 and say that why suddenly sugar production has gone down. Why suddenly non-potable alcohol production has gone down? Because it is necessary considering the economic condition of that.
Right, which are the other provisions? Let's quickly run through them.
I'm sorry, my lord. My lord, I'll not take your lordship to anything irrelevant which is not read. I'll read.
Yes, yes.
2. There has been or is likely to be marked a deterioration in the quality of any article or class of articles relatable to that industry or manufactured or produced in the industrial undertaking or undertaking as the case may be. Then 3. There has been or is likely to be a rise in prices of any article or class of articles relatable to that industry or manufactured or produced in the industrial undertaking or undertakings as the case may be. And 4, it is necessary to take any such action as is provided in this chapter for the purpose of conserving any resources of national importance which are utilized in the industry or the industrial undertaking or undertakings as the case may be. Then, my lords, may kindly come to 16. For powers of the central government on completion of investigation. Then A, power is to regulate the production of any article or class of articles by the industrial undertaking or undertakings and fixing the standard of production. Then C, B I am skipping. C, prohibiting the industrial undertaking or undertakings from resorting to any act or practice which might reduce its or their production capacity or economic value. Well, suppose we need industrial alcohol for sanitizer and majority of the industrial alcohol goes for manufacturing of potable intoxicating liquor. But the government can step in and say that circumstances exist that we give up our forbearance, we step in and we exercise this power. Controlling the prices or regulating the distribution of any article or class of articles which have been the subject matter of investigation. My lord, now price control is, my lord, your lordship may mark entry 34 list 3. Then your lordships have, my lord, seen 18 my lord, several provisions. I am not, I don't intend to read them, my lord. Please come to 18G. This is the only provision which is considered. Page 577, my lord, your lordship would take, of volume 4. Your lordships have that? May I read?
Yeah.
Power to control supply, distribution, price, etc. of certain articles. The central government, so far as it appears to it to be necessary or expedient, for securing equitable distribution and availability at fair prices. This is the condition. Which condition may arise in future, even with regard to scheduled industries which are today exempted.
Yes.
Please go further, my lord. At fair prices or any article or class of articles relatable to any scheduled industry. Lord, the relatable means raw material also. The only condition is that it should be formation of an opinion that it is required for securing a equitable distribution and availability at the fair prices at a national level. So not only the production, the price, the quality, the manufacturing activity, but even related products also can be regulated. Lord, scheduled industry may, notwithstanding anything contained in any other provisions of this act, by notified order. Lord, this is one contention which I'll separately deal with, my lord, in a very short span. Notified order provide for regulating the supply and distribution thereof and trade and commerce therein. My lord, the expressions under 33, list 3, 33. Then, without prejudice to the generality of the powers conferred by subsection 1, a notified order made thereunder may provide a for controlling the prices at which any such article or class thereof may be bought or sold. Price control. Then, my lord, C, prohibiting the withholding from sale of any such article or class thereof ordinarily kept for sale. Then D. And D is relevant, my lord, even for the purpose of answering that notified order question, my lord. For requiring any person manufacturing, producing, or holding in stock any such article or class thereof to sell the whole or part of the article so manufactured or produced during a specified period. So, notified order can be for a specified period also. The power before that date and after that specified date still remains. Or to sell the whole or a part of the article so held in stock to such person or class of persons and in such circumstances as may be specified in the order. Then E, for regulating or prohibiting any class of commercial or financial transactions. See the width of the act, my lord. It occupies the field totally. or for regulating or prohibiting any class of commercial or financial transactions relating to such article or class thereof, which, in the opinion of the authority making the order, are, or if unregulated, are likely to be detrimental to public interest. Even this can be done if public interest requires. It would normally not be done. That is forbearance. When it is done by way of a notified order. But the power remains.
But the impact of the forbearance, really, that's the point which you will have to meet, which is that today, except for four industries, cigarettes, electronic or aerospace, industrial explosives, and hazardous chemicals, all other industries have been exempt from the provisions of the statute. The
This
power under section 29B has been utilized, you said. So, though theoretically speaking, the government, of course, the authority which issues an exemption can withdraw it. There's nothing to prevent the government from again withdrawing the exemption for one or more industries. Today, as the position stands, industrial alcohol per se stands exempted from the provisions of the Act, right? Now, in a theoretical future, the government can, of course, withdraw the exemption if it sees, as you rightly said, suppose, there's a COVID-like situation arose, and hopefully we hope it will never again arise.
Yes, anywhere in the world. Yes.
Anywhere in the world. But as you said that, you required sanitizers, therefore you had to control the production of alcohol used for sanitizers. Fair enough. But if the government has, as of a given point of time, exempted an industry completely from the operation of the Act, right? So as to obviate any exercise of the power under section 18G at that time, then other states
or other provisions,
or other states then denuded of the power to regulate that industry.
No, my lord. My lord, I'll just point out, my lord.
The exemption from the provisions of the statute covers everything or only licensing?
Only licensing, not section 2. Section 2, which is a declaration under entry 52. I just read, your lordship need not open. Section 2 of the IDRA, declaration as to expediency of control by union. It is hereby declared that it is expedient in public interest that union should take under its control the industries specified in the first schedule. This is not exempted. This operates. The regime of licensing is under the forbearance. But otherwise, what happens? And whether, my lord, I'm posing a question to myself, your lordships would interpret it in that manner that this is the result. What happens if your lordships were to say that so long as there is a notified order, the state would be denuded of its powers? If there is no notified order and we are in a forbearance, we means the central government is in a forbearance regime, they would have the power. My lord, the question I'm posing to myself is, my lord, can that be the jurisdictional ping pong? That if I interfere, they may have a law that would stop from operating because now there is a notified order. The moment I withdraw that notified order, they again either bring new law or their earlier law becomes operative. But that's not the intention. Therefore, my lord, my lord, at the outset said that what is relevant is, does this act occupy or intends to occupy entire field or not? It occupies, my lord, right from raw material, pricing, quality, production, lack of production, investigation, manufacturing, final goods, finished products, sale. Everything is, my lord, occupied. And once there is a law, my lord, there is a judgment which says that even a non-operative law, if it occupies the field and if it's a central law, the state government is denuded. My lord, that I'll read that judgment, my lord. What happened was that, my lord, in that judgment, I'll come to that, my lord, a little later. My lord, the question was, the central government brought a law. The parliament made a law. it gave it was assented to by the President of India.
Yes.
The law provided that it shall come into force from such date as the central government may appoint. Every law provides. That was not done. And there was a state law, and the argument on behalf of the state was that since the law made by Parliament is not brought into force, there is no question of repugnancy. Repugnancy with what? This court rejected that argument, saying that what Article 254 contemplates is law made by the Parliament, not law in force. If there is a law made by the Parliament and if the field is occupied, then the state is denuded. But I'll come to that judgment, madam.
Yes.
But you have to answer this question of the other side, that entry 8 is outside, entry 8 list 2 is outside the scope of entry 24 of list 2.
That's a separate, my lord. Yes, I will have to answer that. I will, my lord, I'll immediately after that, my lord, I'll come on that. I'm just, my lord, trying to show that the Central Act occupies the field and intends to occupy the field, because that
But from 18G?
22. So there is a development council contemplated, my lord, which
Okay, that's a direction to the development council. nothing major.
no, yes, my lord, please see 25, my lord, or 26. My lord. Power to issue directions. The central government may give directions to any state government as to carrying into execution in the state of any of the provisions of this act. Not completely supervening legislation. And last, your lordships may see, right. But 31 also, but I must show your lordships fully. Application of other laws not barred. The provisions of this act shall be in addition to and not save as otherwise expressly provided in this act in derogation of any other central act for the time being in force. The state act is barred. Lord, when I read the judgments on repugnancy, and there are only 3 judgments which I'll read, Lord, this would be relevant. When I'll be able, my Lord, I would attempt to satisfy your lordships that there is a legislative intent to occupy the field fully and completely. Now, your lordships, my Lord, only see as a last, my Lord, point on IRDA. My Lord, very quickly, please come to, my Lord. I'll complete this within 10 minutes. The history of, my Lord, this act, my Lord, how alcohol is dealt with, my Lord. That is at page 56 of my written submissions, my Lord, 2D, volume 2D. I'll read only the my Lord, title, not read, my Lord, the whole thing. Because, my Lord, the Chief Justice's question whether alcohol is right now under regulated category or not, my Lord, some part of it is therefore. My Lord. The second purpose of showing the history is
D. Written service.
56 of my written submissions, my lord. Volume 2D, 2 capital D, D for Delhi. The purpose is, my lord, it has always remained with the center, historically. My lord, Indian Power Alcohol Act used to govern 1948. Then comes, my lord, Indian Power Alcohol Amendment. I'm sorry, my lord. But Indian Power Alcohol Act used to govern, page 56. My lord. Then 57, Indian Power Alcohol Amendment Act came into force. Then central government constituted Alcohol Committee in 1956. Then my lord, this order came to be passed, my lord, under 18G of IDRA, Ethyl Alcohol Price Control Order. Your lordships need not read it, my lord. Then your lordships may kindly come to 69, National Biofuel Policy 2018. Lord, this is a very, very ambitious policy. And since we have the problems with fuel because it has its international implications, we are dependent upon some circumstances, my lord, in other countries, etc. So our country is, my lord, kind of trying, my lord, whether there is any alternative is available. The central government notified National Biofuel Policy on 4th June 2018 in the Gazette after it was approved by the Cabinet on 16th May 2018 with a view to promote biofuels in the country through structured program like ethanol blended petrol program, National Biodiesel Mission, Biodiesel Blending Program. The Niti Aayog in its report dated 2nd of June 21, Roadmap for Ethanol Blending in India 2020-25 made several recommendations to ensure uniform availability at a national level. Therefore, it can be done at state level of ethanol blends in the country. During the outbreak of COVID-19 pandemic, several orders were issued to ensure availability of ethanol at the notified price for the manufacture of sanitizers. In its product publication, Ministry of Petroleum and Natural Gas named Ethanol Growth Story has traced the evolution of the use of ethanol and its significance. The government has decided to advance the target of 20% ethanol blending in petrol by 5 years from 2030 to 2025. This necessarily needs control, central government regulation, pan-India implementation. Well, there may be some notified order which may come with regard to, there may be, I'm not predicting anything as a therefore, my lord, the law still is relevant. That's all, my lord, my objective. As on 30th of November 2023, the ethanol production capacity in the country is about 1380 crore liters, out of which about 874 crore liters is molasses based and about 504 crore liters is grain based. The government of India has been implementing ethanol blended with petrol program throughout the country wherein oil marketing companies sell petrol blended with ethanol. Under EBP program, government has fixed the target of 20% blending of ethanol with petrol by 2025. Further, with a view to enhance the ethanol production capacity in the country to achieve the blending targets set under EBP program, the government has notified various ethanol interest subvention schemes from July 2018 to April 2022. Under this scheme, that is National Biofuel Policy, the government is facilitating entrepreneurs to set up new distilleries, molasses-based, grain-based, and dual feed-based, on or expansion of existing distilleries, same my lord, throughout the country. Interest subvention at 6% per annum or 50% of rate of interest charged by banks or financial institution, whichever is lower, on the loans to be extended by banks and financial institutions is being borne by the central government for 5 years, including 1 year moratorium. this would at some stage need regulation to ensure sufficient quantity of ethanol. But now we are encouraging that we will bear some kind of some portion of interest. There would be a moratorium, invest in this industry, produce more ethanol, let the ethanol be available for the purpose of blending with petrol rather than using it for any other purpose, etc. At some stage, look, this is may not. This is on. Look, this may not directly assist your lordships on answering the questions. Look, this is only apropos. My lords, my lord, very right observation that after 91 liberalization, would this act stand the scrutiny? To which, my lord, my answer was that that's not in question. But relevant, my lord, submission is that this still is in force for a good reason, for a valid reason. And there are situations and circumstances which we may not be able to contemplate now, but which may be required to be, my lord, exercised for the purpose of regulation. That's, my lord, the purpose, my lord. Can I, in 5 minutes, show, my lord, the history of IRDA and switch over, my lord, to the next point?
See, actually, once we Just to sort of summarize what you have, what you have said up to now. One, the expression intoxicating drinks in entry 8 of list 2 covers essentially what is called potable alcohol.
Beverages, yes,
Beverages meant for human consumption.
which has the effect of
Right?
intoxication.
Right. Now, if that is so, denatured spirit, or what we loosely call industrial alcohol, we'll call it denatured spirit, is not within the ambit of entry 8 of list 2. 2. If denatured spirit is not within the ambit of entry 8 of list 2, this is not what you said, but I'm just putting it. It would otherwise have been within the fold of entry 24 of list 2.
That is true.
Right?
I am
One
also,
second,
yes.
just one second. It would have been within the ambit of entry 24 of list 2, which is the provision relating to industries. 3.
Corresponding to
entry
52.
3. Entry 24 of list 2 is subject to entry 52 of list 1. 4. Parliament has enacted a law within in the legislative domain falling under entry 52 of list 1, which specifically covers non-potable alcohol.
Only.
5. Once Parliament has made a declaration under section 50, under entry 52, and has enacted a law, that law covers the entire field. Entry 52 of 6th, entry 52 of list 1, nonetheless, leaves open an area under entry 33 of list 3. But here again, the Industries Development Regulation Act covers the entire field, even in relation to entry 33 of list 3. And to that extent, therefore, the states are denuded, both by virtue, their states are denuded for two reasons. One, denatured spirit, all spirit other than potable liquor, falls within the ambit of entry 52 of list 1. 2, in regard to entry 33 of list 3, Parliament having made a comprehensive legislation on the subject, that covers the field and therefore the states are ousted. I think that's your
I could not have put
these
it
are the
more
6
succinctly than this.
propositions, which I think.
But only one thing which occurred to us, my lord, after my arguments.
So says Sister Nagaratna also says that Article 246(3) makes it very clear that every exercise of power by the state legislature under the state list or under the concurrent list is subject to
list
is subject to list 1 and list 3 exercise of power by the Parliament.
So otherwise also denuded. Lord, one more thing, my lord, just
now I think we can go ahead because we'll like to hear them and rejoin. And now you've made your point.
No, my lord,
I can quickly in rapid fire take us through
only one thing, my lord, and then my lord, I'll
the judgments you can cite.
Yes, my lord. But one thing, my lord. I was just wondering, my lord, in 84 list 1, the word expression used is alcoholic liquor for human consumption. Why it is, my lord? I have already, my lord, argued that 84 is a taxing entry. So please come to page 32.
Now, have you finished this part about the your history of the regulation of alcohol? You want us to see those headings?
One or
just
two.
One or two, just show us so that part is over. Then we don't have to come back to
yes,
it.
Page 61.
Not very strictly relevant, but you can just show it to us so that we'll see the headings. We are rightly only referring to the headings.
Lord, Indian Power Alcohol Act also had a declaration like this, 52. That's all, Lord. Your Lordships need not read it. I have, my Lord, reproduced. My Lord, I have also reproduced, my Lord, whenever there is an amendment made in the IDRA, the statement of objection reasons, and that has remained consistent, my Lord, that is pan-India, uniformity, fair prices. Lord, that is, my Lord, at your Lordships would find page 62. It was amended in 53, my Lord, where 18G, my Lord, came in that amendment, my Lord. My Lord, thereafter, your Lordships can, my Lord, come to page, my Lord, 64. We introduced the central government, or rather the Parliament, introduced, my Lord, fermentation industries as a heading as item number 26 in the schedule. to IDRA. Correct, my lords? I have given, my lord, the statement of objection.
The solicitor, who was the junior who assisted you the most in preparing these propositions?
My lord, all four of us used to sit together for.
But we are going to, at the end, after you finish your argument, we are going to ask your junior to make a 5-minute argument before us. We want them to have the benefit of arguing before 9 judges.
I
So
have,
5
my lord,
minutes, but
I
you
have
have-
requested at the outset, but it's a rare opportunity. They really work very hard.
I
They
just
know
want
the
to put them
subject
on
better
notice
than
so
me.
that- I want to put them on notice so that they are not taken by surprise, that we are going to call upon them, maybe for 2 minutes, just to make
No,
a
my lord,
point.
5 to 7 minutes, my lord, they are fully
Will you
prepared.
make a last minute?
And they are prepared better than me, my lord.
Also call upon only one of them, so we might do that as well.
My
So,
lord,
it's
that
going
may
to
be
be-
difficult for me, my lord, or your lordship to choose. My lord,
So teach to all the juniors to make a point which has not been made by the solicitor.
My lord.
And
my lord, I could not do what your lordships did in 5 minutes. I took 1.5 days.
no.
My lord, they can't do it in 2 minutes.
We-
Let it be 5 seconds.
Our was distillation of the alcohol after you had given us the raw material. See. All right, now what else now? Just let's go quickly now.
Kindly come to, my lord, page 67. And this is relevant, my lord. Therefore, my lord, I must show this. 67. And this was not shown. My lord. Your lordships must have. Lord, judgment in Bihar distillery comes, Lord, authored by, incidentally, nothing, Justice BP Jeevan Reddy. Lord, in 98, Justice Reddy becomes chairman of the Law Commission. And the judgment is, Lord, taken up as a suo moto recommendation to the government.
For that, yes.
Yes, ma'am. And the government, my lord, in the parliament, not government, parliament only accepts the recommendation partly. And this is the stage in, my lord, page 68, where the amendment comes in entry 26 of the IDRA. Lord, page 68, there is an amendment in the act made by the parliament, 14th May 2016. My lord, I have given, if your lordships may read it, my lord, I would earnestly, my lord, request your lordships to read it. Right now, I am not taking your lordships' time, but that would, my lord, reflect the legislative intent that we don't wish to give up the control on non-potable alcohol. So therefore, my lord, what they do was, they only amend the entry, and the entry, my lord, which reads as on now, comes. And that entry is, my lord, as your lordships have already seen, fermentation industries within bracket other than potable alcohol. So potable is consciously kept, my lord, as a part of the schedule to IDRA. And there is a detailed, my lord, statement of objection reasons, which, my lord, I am not taking your lordships through. And last, my lord, even recently, Lord, 23, this act is amended. So just to show, my lord, that the act has not outlived its life. It is still existing. It's still alive. Whenever necessary, it is invoked. That's the only purpose, my lord. Now, your lordships, my lord, kindly come to Tikaramji. My lord, unfortunately,
Actually, before we go to Tikaramji, just see the statement of objects and reasons of that 2016 amendment.
yes,
Just see para 5 at page 69 of your note.
yes, ma'am. Yes, page 69. ma'am.
Para 4, they refer to the Law Commission 158 report.
Yeah,
now
yeah,
just
yes.
see why Parliament did not accept it.
5, my lord. The recommendation of the Law Commission of India was examined in depth by the government. If the subject alcohol is taken out of the first schedule of the Act, both industrial alcohol and potable alcohol would come under the purview of the state government, which is not in consonance with the judgment of the Supreme Court. Moreover, the effect of the implementation of recommendation of the Law Commission would be that the subject alcohol, which covers both industrial alcohol and potable alcohol, would no longer be a central subject. Therefore, it is proposed to amend the first schedule to the Industrial Development and Regulation Act by substituting the heading 26 thereof as fermentation industries within bracket other than potable alcohol, so that it would be in conformity with judgment of the Supreme Court and also ensure that industries engaged in manufacture of alcohol meant for potable purposes shall be under the total and exclusive control of states in all respects. That was the judgment in Bihar distillery. The central government would continue to be responsible for formulating policy and regulating foreign collaboration, foreign direct investment, and foreign technology collaboration agreements for all products of fermentation industries, including industrial alcohol and potable alcohol. So this part of potable alcohol is also controlled, so far as foreign collaboration is concerned.
Yes. That's right. Yes.
I am not going to read all the judgments, I'll read only few paragraphs, except Tikaramji. And there is a reason, Tikaramji also, I don't intend to read the whole, but some parts, the difficulty is, not only here, but earlier also, whenever Tikaramji was followed, only 2 or 3 paragraphs were cited. Out of context. Tikaramji is not what the other side and subsequent judgment says is laid down. That's not what Tikaramji says. Lord, in Tikaramji, the dispute was this limited dispute. And, my lord, the two findings which are consistently being relied upon by subsequent benches and today by the petitioners are in fact obiter. It never fell for consideration. And therefore, there is no discussion also. Now, please bear in mind what was the fact situation in Tikaramji. Lord, sugar, Lord, just on the slight deviation.
Which volume, please?
Volume 5, page 80. Sugar, somebody, my lord, told George Bernard Shaw that, do you know sugar is the only word in English where S is pronounced as SH? His answer was, are you sure? Sure is another word.
Right.
Well, sugar is doubtlessly, my lord, a schedule industry. Sugar is a part of, my lord, IDR.
Yes.
There was a central act governing sugar.
Yes.
The state of UP came out with an act governing sugar cane, which was, my lord, the raw material.
Yes.
That was under challenge by some, my lord, affected parties, including Tikaramji, that the state act is repugnant to the central act. So the examination of the court in Tikaramji judgment was limited as to whether the state act governing sugarcane and the central act governing sugar have any repugnancy.
Yes.
And the only ratio decidendi is there is no repugnancy. Rest of the things, my lord, nobody argued, no, and court, my lord, though observes, but that never fell for consideration. So please come to, my lord, para 2. Para, my lord, first para, my lord, after Justice N.H. Bhagwati. These petitions under Article 32 impugn the validity of UP Sugarcane Regulation and Supply and Regulation of Supply and Purchase Act 1953. 2. The petitioners are sugarcane growers in several villages of district so and so in UP, numbering so in aggregate. The notification dated 27 September 54 issued in exercise of the powers conferred under subsection 1A, read with subsection 2B of section 16 of the Impugned Act ordered so and so, my lord. Please now come to, my lord, straight. Para 8. Lord, it would be page 85 words. On 31st of October 1951, Parliament enacted the Industries Development and Regulation Act 1951 to provide for the development and regulation of certain industries. By Section 2 of the Act, it was declared that it was expedient in public interest that the Union should take under its control the industries specified in the first schedule, etc. My lord. Then, my lord, your lordships, my lord, kindly turn to para 10.
Yes.
Act 65 of 51, my lord, that is IDRA.
Yes.
There is another act also, my lord, that is 10 of, that is Essential Commodities Act, my lord. I'll point out whenever there is a reference to, because the court refers to the act by act number, my lord. Therefore, there is a likelihood of some confusion. Lord, whenever the Honorable Court is being assisted with entries in the list or any constitutional provision, the minimum we are supposed to do is to show the history, the Constituent Assembly debates, etc. That's not shown. Only on that ground, my lord, I can respectfully urge that this is per incuria. I have read, my lord, entry 52, how entry 33 came into picture. What is the history behind entry 24 list 2? Nothing, my lord. No argument, no discussion, my lord. Because there was no, my lord, possibly assistance on that. Page para 10, my lord. Act 65 of 1951 was amended by Act 26 of 53, which by adding chapter 3B, my lord, that is 18G, my lord, your lordships can mark here, my lord, 18G. I'm sorry.
Yes.
Invested the central government inter alia with powers so far as it appeared to it necessary or expedient for securing the equitable distribution as so and so. And 11. On 1/4/55, Parliament enacted Essential Commodities Act 1955, providing for so and so. This is Act number 10 of 55. That is Essential Commodities Act. Your lordships, my lord, kindly see para 12 now. In exercise of the powers conferred by Section 3 of the Act, that is Essential Commodities Act, the central government promulgated on 27th August 55 the Sugar Control Order 1955 and the Sugarcane Control Order 1955. Both were central orders, my lord. The latter empowered the central government, after consultation with such authorities, bodies, and or associations as it may deem fit by notification in the official gazette from time to time, to fix the price of sugarcane and direct payment thereof, and also to regulate the movement of sugarcane. The power to regulate the movement of sugarcane comprised the power to prohibit or restrict or otherwise regulate the export of sugarcane from any area for supply to different factories, and the power to direct that no gur, there is jaggery, or sugar shall be manufactured from sugarcane except under and in accordance with the conditions specified in a license issued in this behalf. Sugarcane was the raw material for sugar. Then, my lord, 14. Only one argument is relevant for the present purpose. Learned counsel for the petitioner urged before us that state of UP had no power to enact the impugned act, as the act is with respect to the subject of industries, the control of which by the union is declared by parliament by law to be expedient in public interest within the meaning of entry 52 list 1 and is therefore within the exclusive province of the parliament. The impugned act is therefore ultra vires the power of state legislature and is a colorable exercise of legislative power of the state. The impugned act is repugnant to, that is IDRA, and Act 10, that is Essential Commodities Act, and in the event of court holding that impugned act was within legislative competence of the state legislature, it is void by reason of repugnancy. Rest is, my lord, challenge under Article 14, 19, 1G, etc., with which we are not concerned. My lord, please see 15. This contention relates to the legislative competence of UP legislature to enact the impugned act, that is, my lord, Sugarcane, UP Sugarcane Act. It was contended that even though the impugned act purported to legislate in regard to sugarcane required for use in sugar factories, it was in pith and substance and in true nature and effect legislation in regard to sugar industry which had been declared by Act 65 of 51, that is IDRA, to be an industry and the control of which the union was expedient in public interest and was therefore within the exclusive province of parliament under entry 52 list 1. The word industry, it was contended, was a word of wide import and included not only the process of manufacture or production, but also things which were necessary, incidental to it, that is raw materials. Because that was the fact situation. One state was dealing with sugarcane, center was dealing with sugar and sugarcane both. For the industry, as also the product of that industry and would therefore include within its connotation the production, supply, and distribution of raw materials for which for the industry, which meant sugarcane in relation to sugar industry. It was also contended that insofar as the impugned act purported to legislate in regard to sugarcane, which was necessary ingredient in production of sugar, it was colorable exercise, etc. Then, my lord, 16. It was contended on behalf of the state, on the other hand, that after the advent of war and the proclamation of emergency under 102 of Government of India Act and by so and so, your lordships may directly come to, my lord, the third constitutional amendment act amending entry 33 of list 3, the central legislature turn was operating all along on what became the effect of concurrent field even in regard to sugarcane, that the investing the central government with the power to legislate in the sphere of provincial list did not deprive the provincial legislature of such power, and that both the central legislature as well as state legislature had legislative competence to legislate in regard to these fields, which were for the purpose of legislative competence translated into concurrence field, and that therefore the UP state legislature was competent to enact the impugned act, which would be valid within its own sphere except for repugnancy with any of the provisions of the central legislature covering the same field. So they say for sugarcane we are entitled. You go section by section, whatever is repugnant, the central law will prevail. Then, my lord, kindly come to 18. Production, supply, and distribution of goods was no doubt within the exclusive sphere of the state legislature, but it was subject to provisions of entry 33 of list 3, which gave concurrent powers of legislation to the union as well as the states in the manner of trade and commerce in and production, supply, and distribution of the products of industries, where the control of such industries by the union was declared by parliament to so and so, so and so. Then, my lord, somewhere, there is no classitim. After entry 52 list 1, which was exclusive province of parliament, leaving other industries within entry 24 of list 2, which was the exclusive province of state. The products of industries which were comprised in entry 24 were dealt with by the state legislature, which had under entry 27 of that list power to legislate in regard to production, supply, and distribution of goods. Goods according to the definition contained in Article 366 of 366(12), including all raw materials, commodities, and articles. This is one of the findings. that raw material would not fall under 24 or 52, it would fall under 27 because it says goods. And according to Tikaram, goods means raw material. But 27 says subject to 33, which I'll show. When, however, it came to the products of the controlled industries comprised in entry 52 of list 1, trade and commerce in, and production, supply and distribution of these goods became the subject matter of entry 33 of list 3, and both parliament and the state legislature had jurisdiction to legislate in regard thereto. The amendment of entry 33 of list 3 by the Constitution 3rd Amendment Act only enlarged the scope of that entry without in any manner whatsoever detracting from the legislative competence of Parliament and the state legislature to legislate in regard to the same. Look, this, in my respectful submission, is wrong if we go by 27. Entry 27 says goods subject to 33. If the matters had stood there, the sugar industry being a controlled industry, legislation in regard to the same would have been in exclusive province of Parliament, and production, supply and distribution of product of sugar industry, that is sugar, as a finished product would have been within entry 33 list 3. Sugarcane would certainly not have been comprised within entry 33 of list 3, as it was not the product of sugar industry, which was a controlled industry. Kindly pause here for a minute. When we say control of industry, the term industry would include right from raw material till the finished products. But Supreme Court in Tikaramji throughout goes that no, raw material is outside. For final product, you have to rely on 33. And gave a restricted and contrived meaning to the term industry under list 1.
Under Article 366, Clause 12, the expression goods is defined.
Correct.
To mean it's an inclusive definition, includes all materials, commodities and articles.
Correct, my lord. But I will show, my lord, if the
That
way...
is a definition which is already given in the Constitution as to what goods refers to.
But, my lord, that doesn't come in the way of my submission for the simple reason that the term goods are used in entry 27.
And in entry.
Which is subject to 33, which is a concurrent subject, my lord. Yes, but definition clause is always unless the context otherwise.
It is not a restricted definition, it is an inclusive definition.
I am not on goods, restricted definition of industry, my lord, which I will come to. Entry 33 of list 2 by the Constitution 3rd Amendment Act that foodstuffs including edible oil seeds and oils came to be included within that list, and it was possible to legislate in regard to sugarcane having recourse to entry 33 of list 3, say for that sugarcane being goods fell directly within entry 27 list 2 and was within the exclusive jurisdiction of the state legislature. Production, supply and distribution of sugarcane being thus within exclusive sphere of the state legislature, the UP state legislature would be without anything more competent to legislate in regard to the same, and impugn act would be intra vires the state legislature. This is the argument. The argument, however, was that the word industry was a word of wide import and should be construed. My lord, kindly read. This is, my lord, considered to be the ratio. The argument, however, was that the word industry was a word of wide import and should be construed as including not only the process of manufacture or production, but also activities antecedent thereto, such as acquisition of raw materials, and subsequent thereto, such as disposal of finished products of that industry. My lord, I have shown to your lordships in IDRA that right from the raw material till finished products, everything is covered. Because it says articles, products relatable to the scheduled products.
Section 18G that you read to say.
And 15 also, 15 also.
Relatable and 15 also.
Also.
So by the word use of the word article relatable, you are saying that raw material would also come in with sugar, the final product, which is in the domain of the union.
idea. And Manoj, the Tikaramji ultimately says that industry would only mean only that manufacturing part. That's the finding, only manufacture. Manoj, now kindly see the Manoj, the difficulty.
Material.
May continue at 2 minutes. My lords.
As we are breaking in that volume 2D, at page 57, what is referred to is an alcohol committee.
Correct.
Would like to be informed what are the qualifications needed to be a member of the alcohol committee and whether
They were competent.
bar members, they have a, straight route to the alcohol committee.
Whether they were competent and eligible.
They are members of the bar.
The bar.
The bar, yes.
Obviously be relatable to the industry.
Of course, that is
committee.
denatured. That is denatured committee, of course.
Yes, Mr. Wellston.
Yes. My lord, during lunch, my lord, I have further, my lord, so what I am arguing now, my lord, is further abridged edition, my lord.
Yeah.
My lord, I was on para 19. The argument, however, was that the word industry was a word of wide import and should be construed as including not only the process of manufacture and production, but also activities antecedent thereto, such as acquisition of raw materials, subsequent thereto, such as disposal of finished products of that industry. The process of acquiring raw materials was an integral part of industrial process and was, therefore, included in the connotation of the word industry. And when the central legislature was invested with the power to legislate in regard to sugar industry, which was a controlled industry, it should be scheduled industry, by entry 51 list 1, that legislative power included also the power to legislate in regard to the raw material of the sugar industry, that is sugarcane, and the production, supply, and distribution of sugarcane was, by reason of its being necessary ingredient in the process of manufacture or production of sugar, within legislative competence of the central legislation. Each entry in the list, which is a category of head of the subject matter of legislation, must be construed not in a narrow or restricted sense, but as widely as possible so as to extend to all ancillary or subsidiary matters which can fairly and reasonably be said to be comprehended in it. Thereafter, your lordships may kindly come to, my lord, just above para 21, what we are concerned with, my lord. Your lordship gets, my lord. What we are concerned with here is not the wide construction to be put on the term industry as such, but whether the raw material of an industry which form an integral part of the process are within the topic of industry, which forms the subject matter of item 52 of list 1, as ancillary or subsidiary matters which can fairly or reasonably be said to be comprehended in that topic, and whether the central legislature, while legislating upon sugar industry, could, acting within the sphere of entry 52 list 1, as well legislate upon the sugar cane. If both the central legislature and the provincial legislature were entitled to legislate in regard to this subject of production, supply, and distribution of sugar cane, there would arise no question of legislative competence of the provincial legislature in the matter of having enacted the impugned act. The conflict, if any, arose by reason of the interpretation which was sought to be put on the two entries. Entry 62 of list 1 and 27 of list 2 put in juxtaposition. 62 is a typo, my lord. It should be 52. Put in juxtaposition with each other. It was suggested that item 62 of list 1 comprised not only the legislation in regard to sugar industry, but also in regard to sugar cane, which was an essential ingredient of the industrial process of manufacture or production of sugar, and was therefore ancillary to it and was covered within the topic. If the legislation with regard to sugarcane thus came within the exclusive province of the central legislature, the provincial legislature was not entitled to legislate upon the same by having resort to entry 27 of list 2, and the impugned act was therefore ultra vires the provincial legislature. My lord, rest your lordship can skip. Some judgment is cited. Kindly come to, my lord, para 22, after the quotation, my lord, in Subramaniam Chettiar. Am I with your lordship?
Yes.
And it was contended that entry 27 of list 2 should be construed in a general manner as applying to production, supply, and distribution of goods in general. And entry 52 of list 1 should be construed as comprehending within its scope ancillary matters in relation to the controlled industries, thus excluding production, supply, and distribution of goods, which would be thus comprised within it as ancillary matters from the sphere of entry 27. The argument was that read state entry in a wider sense and the central entry 52 in a restrictive sense. If this construction was adopted, it would avoid the apparent conflict between the two entries and would reconcile the power of the provincial legislature with those of the central legislature. It was therefore contended that the legislation in regard to sugarcane should be considered as ancillary to the legislation in regard to sugar industry, which is a controlled industry and comprised within entry 52 list 1 and should be excluded from entry 27 list 2, which should be read as covering only those categories which did not fall within entry 52 of list 1, even though on a wide construction of the word production, supply and distribution of goods, they would be capable of covering the same. If this construction was put upon these two entries, it would follow that the subject matter of the impugned act was within exclusive jurisdiction of Parliament, being comprised in entry 52 list 1 and was ultra vires the UP state legislature. The answer of the state of UP was twofold. One, after the advent of Second World War, my lord, your lordship can skip. Two, that the impugned act merely confined itself to the legislation in regard to sugarcane and did not purport to legislate in regard to sugar, which was exclusively dealt with by the centre. There was therefore no trespass upon the exclusive jurisdiction. My lord, 23, your lordships can skip, my lord. Just, my lord, above 24, sugar and sugar cane, thus, my lord, your lordships can, that also your lordships can skip, my lord. It's interplay between essential commodities act and sugar, my lord. Nothing would assist your lordships, my lord. Para 24 is the finding. It is clear, therefore, that all the acts and the notifications issued thereunder by the centre in regard to sugar and sugar cane were enacted in exercise of the concurrent jurisdiction. They don't, let's say 27, they resort to 33. The exercise of such concurrent jurisdiction would not deprive the provincial legislature of similar powers. This is the ratio which they had under the provincial legislative list, and there would therefore be no question of legislative incompetence qua the provincial legislature in regard to similar pieces of legislation enacted by the latter. The provincial legislature as well as central legislature would be competent to enact such pieces of legislation, and no question of legislative competence would arise. It also follows as a necessary corollary that even though sugar industry was a controlled industry, none of these acts enacted by the centre was in exercise of its jurisdiction under entry 52 list 1. Industry in the wide sense of the term would be capable of comprising three different aspects. Please mark this, my lord. One, raw materials, which are an integral part of the industrial process. Two, the process of manufacture or production. And three, the distribution of production of the products of the industry. The raw material would be goods, which would be comprised in entry 27 of list 2. This is where in my submission, my lord, there is an error in law. If the first part is right, then industry encompasses everything from raw material to supply and distribution of final product.
Exception to.
May I, my lord, continue reading?
Yes.
The raw material would be goods which would be comprised in entry 27 list 2. The court is not, my lord, invited to see entry 33 here, that it is in entry 33 also.
That's in the next sentence. Then.
The process of, yes, my lord, the process of manufacture or production would be comprised in entry 24 of list 2, except where the industry was a controlled industry, when it would fall within entry 52 of list 1, and the products of the industry would also be comprised in entry 27 of list 2, except where there were the products of control industries, where they would fall within entry 33 of list 3. This being the position, it cannot be said that the legislation which was enacted by the center in regard to sugar and sugarcane could fall within entry 52 of list 1. Well, this is under the Essential Commodities Act, not my lord IDRA Act. Before sugar industry became a controlled industry, both sugar and sugarcane fell within entry 27 of list 2. But after a declaration was made by Parliament in 1951 Act, but this is IDRA, that is by Act 65 of 51, sugar industry became a controlled industry, and the product of that industry, that is sugar, was comprised in entry 33, list 3, taking it out of entry 27 of list 2. Even so, the center as well as the provincial legislature had concurrent jurisdiction in regard to the same. I have no difficulty, that is so. In no event could the legislation in regard to sugar and sugarcane be thus included within entry 52 of list 1. This is wrong, in my respectful submission. It's a scheduled industry. 52 provides for a declaration. Declaration is made that these industries will fall within 52, and therefore the Parliament did it. The pith and substance argument also cannot be imported here for the simple reason that when both the center as well as the state legislatures were operating in the concurrent field, there was no question of any trespass upon the exclusive jurisdiction vested in center under entry 52 of list 1. Only question which survived being whether putting both the pieces of legislation enacted by the center and the state legislature together, there was any repugnancy, a contention which will be dealt with hereafter. This is what the question was. But your lordships would find, my lord, there is no reasoning, discussion, or finding why sugar or sugarcane cannot be a part of a legislation under entry 52 list 1. It can be, my lord, declared by the Parliament to be an industry which needs control by the central government. The court proceeds on a footing that it falls only under 33, and 33 being concurrent, both have the jurisdiction. Now we will examine whether there is any repugnancy. Now further.
No, entry 33 is also having a relationship with entry 52. list
52,
1.
even 27 has a relationship, is subject to 33.
So
and
it is not
in fact-
before entry 52.
In fact, if there was no entry 33 in list 1, those products should fall under entry 52 of list 1,
Yes.
isn't it?
Yes.
If there was no entry 33.
Would have exclusively to the center, my lord. Now, my lord, a more
That threefold dichotomy between raw material, manufacture, and products, that may not be, as a matter of abstract proposition, that may not be correct. Now, products are separated out by a constitutional entry, but that constitutional entry indicates that but for it, the product should have gone to entry 52 of list 1, probably.
I'm grateful.
And raw material can be.
I'll show. They remain in the state list otherwise. But please see, word industry emanates from the state list 24. Now, when we demarcate the field of industry, whether it is taken over or not, then we have to notice the other comparable entries. Now, what happens is, Lord, if industry comes in 24, then the product goes to 26, 27. And if raw material, if it is good, as the judgment says, and it is not, electricity is a good which we can't even see.
definition-
signals are-
When a product would be a good, my lord, final
So
product
therefore, raw
would be.
material also goes in entry 27, which means deals with goods.
But 27 is subject to 33. My lord, the question, but my learned friend has put a wrong question. The question should be, why should it not fall under 52? Suppose 33 would not have been there, entirely, exclusively under 52. Now 33 means you have to exercise central power and concurrent powers. And both would oust, when exercised by the Parliament, the state legislature. That's the, in my respectful submission, the correct rationale. But that is, my lord, missing.
That's
Then
why it
20.
is called clause 3 is subject to clause 1 and 2 under
Correct.
article 246.
It's
It is subject to.
correct. Well, 25. A more effective answer is furnished by the comparison of the terms of UP Act number so and so with those of impugned Act. Whereas, my lord, now they compare both the acts, my lord, with which we are not concerned. They said there is no repugnancy because both operate on separate fields. Why? One deals with raw material, another deals with only manufacture. Now, my lord, 25 last para, my lord, just above 26. This comparison, your lordship gets one.
Yes.
This comparison goes to show that the impugned act merely confined itself to the regulation of the supply and purchase of sugarcane required for use in sugar factories and did not concern itself at all with the controlling or licensing of sugar factories, with the production or manufacture of sugar, or with the trade and commerce in and production, supply and distribution of sugar. If that was so, there was no question whatever of its trenching upon the jurisdiction of the center in regard to sugar industry, which was a controlled industry within entry 52, list 1, and the UP legislature had jurisdiction to enact the law with regard to sugarcane because they bifurcated raw material.
So,
And
Mr. Solicitor, your argument is that then entry 52 is broad enough to include even the products.
correct. Read with 33.
Read with 33.
Yes. Now, my lord, further. Then your lordships may, my lord, kindly see. Now, my lord, they could have, my lord, possibly stopped at that, but please come to page 31. Para 31, I'm sorry, my lord. My lord, this is reliance upon para 30, my lord, first. Suleiman J. in Shyamkant Lal versus Ram Bhajan Singh. And at the foot, what they rely upon is Attorney General for Ontario versus Attorney General for Dominion. My lord, it's on record, but I'm not reading it. I'll just orally point out, my lord, how that judgment is completely not relevant or, my lord, in facts of the case. But what happened in Ontario? Ontario is a province in Canada. My lord, your lordships are aware, my lords are aware, our 254 is, my lord, inspired by section 109 of the Australian Constitution. It is peri materia. So provisions are peri materia. My lord, I'll give, my lord, Ontario, my lord, in Indian parlance, my lord, so that it's easy for me to make myself clear. My lord, India has a law, take it as a Canadian law. The law says that the law is in two parts. One part, how to deal with a particular commodity, say alcohol. Second part of that central law says whether the state would accept this law or not, the state would decide. For example, Karnataka would decide whether this central law would be applicable in Karnataka or not. How chapter 2 dealt with that there would be a meeting held, there would be a voting take place, and by majority, if they take a decision that we will accept the central legislation, the central legislation would apply to Karnataka, which was, my lord, Ontario in this case. Here, there was no such meeting took place. So central law was not applicable, and Ontario law on the very same subject enacted a law, Ontario being the state. Here, in my example, Karnataka. And therefore, when the question of repugnancy came, the High Court of Australia, which is the highest court, my lord, said that there is no question because in fact, there is no repugnancy because the law is not made applicable. The central law does not apply to Ontario. Look, that is the long and short of this judgment. But what has happened is, my lord, in Shyamkant Lal, one line is picked up. Somebody has cited that repugnancy should be in fact and not merely based on a possibility. Lord, in the instant case, how, my lord, the Tikaramji judgment refers that there is no notified order. So there is a possibility of a notified order. In absence of notified order, there is no question of your applying the central law. Lord, my worry is this. If this logic is right, then all enabling central acts, which enables the central government to do something or not to do something, will become repugnant if the central has chosen not to do something, because they are only enabling, they are not mandate that you will have to do it. Center is enabled, central is empowered to do something. Now in this context, see para 31, which, my lord, in my submission never fell for consideration. In the instant case, there is no question of any inconsistency in actual terms of the acts enacted by Parliament and the impugned act. The only question that arises are whether Parliament and the state legislature sought to exercise their powers over the same subject matter, or whether the laws enacted by the Parliament were intended to be a complete exhaustive code, or in other words, expressly or impliedly evinced an intention to cover the whole field. My lord, this is, my lord, ultimately the law. Your lordships have also, my lord, used the same expression in forum. It would be necessary, therefore, to compare the provisions of Act of 65, that is IDRA, as amended by so and so, and the Sugar Control Order issued thereunder with those of the impugned Act, that is State Act, and UP Sugar Regulation Act. Now, your lordships will kindly come to which is that.
But is overruling Tikaramji really crucial for your line of submissions?
Malord, not the reason, Malord, why Tikaramji, Malord.
Tikaramji, you are really concerned with that threefold bifurcation which they do of manufacture,
and restricting, Malord, I'll just restrict here.
manufacture, raw materials, and.
Malord, para 32 troubles me. And, Malord, this notified order, para 32. Malord, please see para 32. Only para 32, Malord. At 102, Malord. Where's the relevant portion of para number? 97, I'm sorry, 105.
Because, you know, Mr. Solicitor, at a certain level, I'm not sure whether you can say that Tikaramji is an egregious error or anything like that. Because, see, products are separated out of the industry. That's very clear. In relation to list 2, products go to 27. The industry is under 24. The goods come under 27.
Which is subject to 30.
Of course. But 27 is an indicator that the products don't go with the industry. Some products of controlled industries, declared industries under entry 52 of list 1 go under clause A of entry 33 of list 3. So this much is clear that there is a separation of the industries from the products. They either go in respect of state industries, state controlled industries into entry 27.
In unregulated or
union industries, I'm just using that loose expression, under entry 52, the products go to entry 33. So now the only question is that there they to sustain the State Act, they said that, look, the State Act dealt with the raw material, which was sugarcane.
Beyond that, my lord, what is my trouble?
For us to overrule, I mean, your argument may be sustained even on independently of the correctness of.
Lord, the difficulty is the reference order says that synthetics 2 didn't notice Tikaram. And Tikaram, my lord, therefore it becomes necessary. My lord, please see why I have two problems with
No,
Tikaram.
but how does Tikaram, assuming that the reference, the synthetics didn't notice Tikaram, synthetics sustains your position. Suppose synthetics had noticed Tikaram, would that make any difference to
I don't think so. Except, my lord, please come to, my lord, page 105. I have two problems.
I mean, it's because these are older judgments which have stood the test of time.
But only two problems with Tikaram. Only two problems with Tikaram.
Is there no, see, you can always explain away some observation in a judgment.
Yes, my lord, kindly, your lordships can do that. Lord, if your lordships can come to
a judgment which has been followed in our own jurisprudence, you don't know what the large scale impact would be.
No, certainly, my lord, if your lordships can come to para 32, यहाँ पे है, the raw material
irrelevant.
Your argument that the field is not occupied unless there's a notified order, because 18G uses the expression notified order, that we'll deal with separately.
Correct, my lord.
But I'm just trying to see, you may be sort of, you may reflect on it, even after you finish today, in a little while, you can still reflect on it, because that is it strictly necessary for us to start, wielding the axe and go in, overruling an earlier judgment like
Will
this?
be not my.
Or can we not,
my
can
friend.
we not, I mean, we have to hear the petitioners in rejoinder. Can we not independently, or can you not independently sustain your argument even without going to
My lord, I am
Tikaram?
before a larger bench, my lord. The honorable 9 judges would not be bound by Tikaramji, my lord. Whether your lordships overrule, explain, or whatever, my lord, your lordships can definitely take a different view. But my difficulty is one.
Suppose we say that we just cite Tikaram without either overruling it or saying
I
that.
have no, my lord.
But that's why we are asking you, can you not sustain your line of inquiry or your argument, irrespective of the correctness of Tikaram? Or are you in a situation where you have to confront the correctness of Tikaram, otherwise your argument has to be rejected
Lord,
by
if your lordships are persuaded that raw material does not fall within the term industry, A, industry includes only manufacturing, B, and third, in absence of a notified order, there is the field open and the state can
Okay,
live.
let's see that notified order bit of Tikaram. That is para 32, right?
Lord, only, my lord,
Let's
for
see how
my
it deals.
satisfaction, my
I
lord, page
request
105.
Lord, may I request lordships not just to pause for a moment. I'll add on to what my friend is saying. Tikaramji is essential for the reason, Lord, that the alcohol, which is subject matter of dispute in synthetics too, is product of the notified industry, because IDR specifies alcohol industry. So taking it as a product of the notified industry, and the question is sale, distribution, etc., will go where? Because that was a case involving fee being charged for
Go to entry
vending.
33 of list 3.
I mean,
It will go to entry 33 of list 3.
exactly. So then therefore, Lord, the question inevitably arises. Is there a law made under section 18G? Because 18G is traceable to, I'll show.
So the only point then which suffices that even if the product of a of a declared industry goes into entry 33, there is no notified order. That's the only point which we have to still hear the solicitor on that.
And, my lord,
Lord, if my friend permits, both the submissions would survive. Second. First, because synthetics further says that it cannot fall under entry 8. So therefore, we'll have to raise that argument that entry 8 includes industrial alcohol.
but Tikaram is not on that. So,
I'm not. Tikaramji is essential
Whether
because.
whether entry 8 includes industrial alcohol or not is a separate issue. That you have argued, yes.
So therefore, synthetics has to be seen in the context of both the issues.
No, whether intoxicating drinks under entry 8 includes denatured spirit, we have to deal with. There's no difficulty.
Yes.
But I'm only on this, instinctively as a judge, sitting in a combination of 9, because
Lord,
you
if
don't
it's
know
a
what,
product of notified
you don't know
industry.
what the unforeseen, we are looking at it from the point of view of industrial alcohol. As Sister Nagaratna was also saying a moment ago, Tikaramji must have been followed throughout in our jurisprudence.
Yes, yes.
We don't know
2002.
what we will be uncertain
I
if we
feel
just go, hammer and tongs at
no,
Tikaram.
certainly. But I bow down to that. But I am not
So,
in an adversarial.
Therefore, solicitor, yeah, that's exactly.
But
So
I will
you
show.
just see, on the notified order, you can make your argument now, but you can just reflect on it. Maybe just tomorrow is a holiday. You can reflect on it and tell us in 5 minutes day after. Suppose we don't decide to reconsider the correctness of Tikaram. Can you not still sustain your argument on without going into the correctness of Tikaram?
Except that Tikaramji restricts, I'm sorry.
18G. 18G, then you will have to deal with the argument.
Yes. No, Tikaramji restricts the meaning of the word industry to be only manufacturing.
But see,
now the problem.
But solicitor, insofar as industries of the states are concerned, entry 24, the goods go into entry 27 anyway. So whether it's under 24 or 27, they have authority of the goods. Products of a controlled industry, the declared industry under entry 52, they go there. It goes into your power under entry 33, albeit a concurrent power. And there your argument is that, look, but IDRA is comprehensive enough and has occupied the field. If you are right.
My submission. But I'll respond. And
Just
if
reflect on it, because
I'm not right now, taking a lot.
We are a bench of 9. We are untrammeled.
Certainly.
At the same time, when there is a long line of authority which has stood the test of time, it's easier for future benches to distinguish it, say it's not applicable, these were the peculiar facts. Certainly saying, that it's overruled, it's like, I feel
Just to save time.
For certain parties, not the ratio.
you can say, as Brother Oak says, that some part is not the ratio decidendi.
That's my submission.
Really
That's my
necessary.
Industry development. So what
Article, that's right.
Section 15 and section 16. So the bench says when you talk of articles, you mean the manufactured product and not the raw material that goes into the article. That's how they say, please see the explanation to 18G also. Article or articles, class of article or articles. So what Dikaramji says is when you refer to articles, it means the produce, the product which is made, not the raw material.
That's paragraph 32.
32.
Yes, but it
Let's go to
misses.
32 once again, there's that part. Let's see 32 for a minute.
My lord, only bear one factor in mind while reading 32. 18G says article or class of articles relatable to any schedule industry. Not touched at all, my lord, in Tikaramji. Now 32, my lord.
Find it.
Act 65 of 95.
The expression goods includes materials and articles. Under Article 366(12), it includes materials and articles. Both are included.
Yes, yes.
And goods is under entry 27, subject to entry 33 of list 3.
Correct, my lord. My lord, please see 32. Act 65 of 95, 51, that is IDRA, was an act to provide for the development and regulation of certain industries. My lord, your lordships can skip that. Kindly come after 18, my lord, before that, my lord, just above 18G. It did not involve the regulation of the supply and purchase of sugarcane, which, though it formed an integral part of the process of manufacture of sugar, was merely the raw material for the industry and as such not within the purview of the act. This is, my lord, the finding. My lord, tomorrow, my lord, suppose for a defense industry, I am giving a loose example. The central government is required to control the raw material, which is some mineral, some typical mineral, my lord, which is used for producing some defense equipment or some substance. We cannot do that. That will have to be the state's legislature. The center would depend upon the state. And 52 is intended to be an overarching provision that for some industries, uniformity requires the center only to have the power. Then, my lord, further, the act had remained as originally enacted. The provisions of the act would not have been in any manner whatever repugnant to the provisions of UP Act, because both the acts covered different fields. Act 26 of 1903, however, introduced certain amendments. Then, my lord, 18G is quoted, where relatable to any schedule industry is, my lord, specifically added. Thereafter, the court says, sugar industry being one of the schedule industry, it was contended for the petitioners that sugarcane was an article relatable to the sugar industry and was therefore within the scope of section 18G of the central government, was thus authorized by notified order to provide for regulating the supply and distribution thereof and trade and commerce therein. If that was so, it was next contended the field of legislation in regard to sugarcane was covered by this provision of the act and was taken away from the jurisdiction of the state legislature. The avowed intention being to cover the whole field of legislation. It was, however, urged on behalf of the state that articles relatable to scheduled industry comprised only those finished products which were of the same nature or description as the article or class of articles manufactured or produced in the scheduled industry and did not comprise the raw materials. This, my lord, is not coming out, my lord, of the bare reading of the section for the scheduled industry. Reliance was placed in support of this contention on terms of the explanation to section 18G as also section 15 and 16, where the same words, any article or class of articles related to that, relatable to that industry, were used. In our opinion, the contention of the state is sound. The structure of the whole Act 65 of 51, that is IRDA, related to development and regulation of scheduled industries and all provisions which were contained in the Act, including those which were introduced therein by Act 26 of 53, were designed for effectuating that purpose. It is significant to note that even in Section 18G, the regulation which was intended was that of the supply and distribution of article or class of articles relatable to the schedule industry, and the production of those articles was not sought to be regulated at all. The raw material would certainly be essential ingredient in the process of manufacture or production of the articles in the schedule industry, but would not be the same nature or description as the article or class of articles manufactured or produced therein. The whole object of enactment of Section 18G was to secure equitable distribution and availability at fair prices of such articles which, by relation thereof to the article or class of articles manufactured or produced in the schedule industry, would affect such manufacture or production or the supply and distribution thereof or trade or commerce therein. Lord, kindly pause here for a minute. Lord, I have shown the provisions of IDRA which says that even price control is one of the regulations. If we want to control the price, we will necessarily have to control the raw material price or ensure that the raw material is not sold for any other purpose other than the purpose for which, my lord, we are regulating. Not considered. Not only were the article or class of articles relatable to the schedule industry, which were themselves manufactured or produced in this country, but not necessarily, it can be mineral, it can be sugarcane, it can be any grain, agricultural produce, sought to be controlled in this manner, but also the articles or class of articles imported into India, which were of the same nature or description as the article or class of articles manufactured or produced in schedule industry, so that all these articles, whether indigenous or imported, would be controlled by the central government by regulating the supply and distribution thereof and trade and commerce therein, with a view to develop and regulate and thus control the schedule industries in public interest. Section 15 of the Act provided that where the central government was of the opinion that in respect of any schedule industry or industrial undertaking there had been or was likely to be a substantial fall in volume of production in respect of any article or class of articles relatable to that industry or manufactured or produced in the industrial undertaking for which, having regard to the economic condition prevailing, there was no justification, it may make or cause to be made full and complete investigation into the circumstances. But Lord, suppose the raw material production started falling, the government can inquire into it, my lord, in a given set of facts, that why raw material has started falling. As a result, the production has started getting affected. If after making or causing to be made any such investigations, the central government was satisfied that action under Section 16 was desirable, it was to issue such directions to the industrial undertakings concerned as may be appropriate for regulating production of any
para 32 of Tikaramji, that's a little bit of a problem.
It's an obiter, my lord.
And
according-
that's an obiter. We can say that they were not called upon to really decide that.
Decide that.
And actually, that may not be a correct approach also, because they say repugnancy must exist in fact and not depend merely on a possibility. There are two ways in which, the conflict has to be addressed under the concurrent list. One, where the central law says something and the state law mandates exactly to the contrary.
Can't coexist.
They both can't coexist. The second may be where the central law, by virtue of the comprehensive nature of its provisions, excludes any legislation by the state. If I was just telling my colleagues, our judgment in that West Bengal RERA case, West Bengal HERA
That is
case,
forum.
forum,
Forum.
where the state law was identical to the central law.
Yes.
And the argument of Mr. Dwivedi in that case was that, look, what have we done? We have enacted a law which is identical to the central law. Where are we barred from making a law which is identical to the central law? That was the argument of Mr. Dwivedi, Mr. Rakesh Dwivedi. We overruled it and set aside the state law, saying that, look, once the central
Occupying
law,
the-
RERA has held the field, the state cannot enact a law even on all fours with the central law. So, repugnancy in the sense that, they can't both stand together is one aspect of repugnancy. And this part about 18G, the notified order, there may be a way out of it. You see, 18G confers power on Parliament to regulate production, supply, distribution, etc. By a note, and says 18G says that the central government may, by a notified order, provide XYZ. Now, the issuance of a notified order is an administrative act. This cannot be determinative about the field which is occupied by Parliament.
Absolutely, my lord. My lord, in Mariyar Prem, this exactly was the situation. But I'll just give me 2 minutes. I'll not
So
cite,
now we've seen this para 32. What do you want to show us in Tikaramji so that we
but
can
this
then
is
now
all.
wrap
My
up?
lord, Tikaramji is over.
think,
Tikaramji judgment is over. My lord, we have my lord, Talak doubts Tikaramji.
Which one? Who doubts it?
Talak, my lord. My lord, if your lordships can.
Talak.
First, my lord, it is doubting in Hingar Rampur, my lords. Hingir Rampur, I'm sorry, ma'am. Hingir Rampur, ma, we have cited in minerals matter and bench was same, so I'll not read them. Thereafter, my lord, I have, if my learned friend can, my lord, we have prepared a list of follow-up judgments of Tikaramji, my lord, if 4I.
अब हो गया पूरा आ गया अभी नहीं आया
My lord, I have page 78 of my written submission. I have quoted para 30.
Only that has to.
Let me give the para numbers only, my lord, how it is followed. I'll without reading it, my lords.
para
But first
Page
you-
78.
Give us the citation first.
Yes, my lord. It is, I'll give the Hingir Rampur first, my lord. Hingir Rampur is, because it was first doubted in Hingir Rampur. Page 80, para 92 of my written submissions. I have quoted, my lord. Therefore, your lordships may get a immediate
page
uh,
page 82
80.
Volume?
2D
80, my lord. Hingir Rampur, my lord, the citation is 1961, volume 2, SCR 537. And if your lordships would like to go through the whole judgment, my lord, it's on record. On that page 80, my lord, we have given the citation, PDF volume 5F, page 409. Then to law, I'm sorry, madam. So Tulloch is page 78, para 91. I have quoted, my lord, para 13 in extenso. Citation is, it's a, my lord, 5-judge bench judgment again, 1964, volume 4, SCR 461. It is same volume, my lord, volume 5, capital B, page 113.
The earlier one was page 5F, no, you said.
5B, my lord. Volume 5B.
Hingirampur was volume?
Ingir Rampur is 5F.
Yeah, and Tulox is volume 5B.
5B, page 113. Para 13, which is quoted in my written submissions at page 78, 79 onwards.
The test of two legislations containing contradictory provisions is not, however, the only criterion of repugnancy. For if a competent legislature with a superior efficacy expressly or impliedly evinces by its legislation an intention to cover the whole field, the enactments of the other legislature, whether passed before or after, would be overborne on the ground of repugnance. Where such is the position, the inconsistency is demonstrated not by a detailed comparison of provisions of the two statutes, but by the mere existence of the two pieces of legislation.
Yes, that's what your judgment says. Now this dual.
Look, so there is one judgment, my lord, of Andhra Pradesh High Court, my lord.
93.
Para 93, page 81.
That is correct.
No, there is one judgment of Andhra Pradesh High Court by Justice B.P. Jeevan Reddy, my lord. But again, Andhra Pradesh High Court, my lord, that is 1988 SCC Online, AP, Andhra Pradesh, page 129, which is quoted in page 75,
AP page,
129,
where do we find it?
page 75 of my written submissions, my lord, 2D, volume 2D. And judgment is volume 5K, page 2. Entire judgment, but the relevant paragraph, entire, my lord, in 3 pages, my lord, I have quoted. Where Tikaramji is doubted, but ultimately the court takes a different route, my lord, and obviously, my lord, High Court could not have.
Or in the nature of arbiter. It's that.
Okay.
Even arbiter would be binding, my lord. So it notes and says that this.
Arbiter. Note sense says that.
Because Draupadi says, even assuming.
That's
last para 32
right.
is saying, even assuming.
That it
That's
should have
right.
been issued.
That's right.
It was not called upon to decide, but said something.
The act of- That was the first of last sentence.
Notification. That's
So
right.
no discussion. But otherwise, my lord, what happens is, my lord, what happens, my lord, the ratio in Mariyar Prem, my lord, is this. Mar Apriyam. Mar Apriyam.
You know what word he will not be able to pronounce.
Mar Apriyam, my lord.
We'll make Mr. Dwivedi also make a try at it, you see.
I would not like to attempt even.
Well, there, the court had beautifully said, well, their argument was, as I have indicated, act was passed.
Yes.
Assented to by the President of India. At that moment, law is made as contemplated under Article 254(1). It was not brought into force. So there is always a commencement date. It would commence from the date it is notified by the central government. Well, the court said that it is a law made by Parliament, assented to by the President of India. The existence of the law cannot depend upon an executive action or inaction of not bringing it into operation. So therefore, it is a law, and if it is in conflict with some other state law, repugnancy will have to be tested. It's a constitution bench judgment.
Yes, Mr.
Lord, that is, Lord, I'll just give the citation on this, Lord, obiter part, Lord, page 82 of my written submissions, Lord, para 94, State of Kerala versus Mar Apriyam Puri Company Limited, which Lord takes note of Tulok. Mar Apriyam, Lord, and the entire judgment is volume 5. 5, Lord. Only 5, Lord. 5. PDF page 2382. Lord, my learned friend cited ITC Limited, my Lord, her ladyship Justice Ruma Pal's majority view.
Yes.
Lord, the minority view of my Lord Justice Patnaik and Justice Bharucha. Lord, I'll just give the page numbers. My Lord, it says exactly opposite, my Lord. With the submissions, my Lord, which I am respectfully canvassing for your Lordship's acceptance. May I read or give the page para numbers, my Lord?
Just the para numbers.
Para numbers, my Lord. Lord, my note at 2G.
2D, no?
2G, my Lord. It is filed not on record, my Lord. It was uploaded yesterday in time, but could not reach your Lordships, my Lord. Lord, para 8, we have said Tikaramji is followed in following judgments, and one of them is, my Lord, ITC, and dissent of Justice Patnaik and Justice Bharucha is para 189. Page 705. Page 189. It's a detailed discussion, my Lord, on why my Lord, majority is wrong, and therefore Tikaramji is wrong. My Lord, it is page 1705 of volume 5. At, my Lord, 1705. At. Judgment starts at 1597, volume 5, but para 189 is at 1705. My Lord's judgment, my Lord, the Chief Justice's judgment regarding the RERA, that is Forum for People's Collective Efforts, which I referred to during the course of the day today, forum judgment, this is that judgment, versus State of West Bengal. Citation is 2021, volume 8, SCC 599. Lord, it is volume 5F, page 60.
16.
1660.
Page 60, my lord. Sorry, page 60. And paragraph number is 132, TO2, 132 to 133. Because 132 is in 3-4 paragraphs, my lord. Where your lordships have considered all judgments on repugnancy by occupying the field. And my lord, your lordships are aware. So, my lord, these are my respectful submissions only. My lord, during the course of the recess, my lord, lunch hours, my lord, one fact, my lord, which I just highlight on entry 8. Give me the chart. My lord, I have prepared one chart, my lord. Just for a second, my lord, for a minute, my lord, it won't take more than. Lord, I was just wondering why two different expressions are used. Entry 8 list 2 says intoxicating liquors. Correct, Manoj?
Yes.
Entry 51 is taxing power of the state. It's a taxing entry. Therefore, what it says, alcoholic liquors for human consumption. It doesn't use the word intoxicating. Look, there are two reasons. First, I have already, my lord, assisted your lordship with the taxing entry being a taxing entry, you have to have the incidence of tax, that it would be at what
That you
stage.
had said, yes.
That I have already said. But second, look, there are certain products where there is alcoholic liquor, but it is not intoxicating. For example, cough syrup.
It is really speaking, the item that you are suggesting, it really speaking, not intoxicating depends upon how many bottles you consume.
Yes, yes, the lordships are right, my lord. Anything in excess is poison, my lord. That's what people say, my lord. Even if you drink 5 liters of milk, you might die, my lord. But people are using it for intoxication purpose. But when we interpret the entry, my lord, we will go by the general use, not abuse. Your lordships are right. If you have 2 bottles of cough syrup, you get intoxicated, my lord.
Under the NDPS Act.
Correct? Yes.
For
The thousands of bottles are recovered, my lord, from people who don't have the license to sell, my lord. They are not pharmacy graduates.
They've been prosecuted under Prohibition Act.
Prohibition Act.
So you are saying that the word
Prohibition, this was.
in alcoholic liquors for human consumption is used in entry 51 because firstly, it's a taxing entry and
So
therefore it has to
besides the
indicate the
taxing
basis
event.
of it. Yes.
And second, that there may be alcoholic liquors which are capable of human consumption, but may not have intoxicating effect. I mean, if used, not abused.
Yes.
So these are my respectful submissions.
Thank you.
And I, on that, my lord, Tikaramji, I respond, my lord, day after. My lord, if
Yes.
since this is in continuation and with consent of Mr. Dhruv, my lord, if my colleagues can have 5 minutes each, my lord.
Yes,
It
of
would
course.
be, my lord,
Who will argue first?
all right.
What's your name? Mr. Umar Ahmed. Yes. Yes. 1 second. Umar Ahmed.
Only one argument, my lord, I left. Lord, sorry, my apologies. Lord, so far as synthetics 2 is concerned, my lord, which overrules Balsara.
Yes.
In taking the view that Balsara took the view that liquor includes all types of liquor, whether intoxicating, whether for human consumption, not human consumption, etc. Lord, synthetic says no. Intoxicating liquor for human consumption means something which is a beverage. Lord, I support that. Lord, there was one of the questions, my Lord, which I'm duty bound, my Lord, to answer, where according to me, going, my Lord, reading, my Lord, I can read, my Lord, 4 or 5 paragraphs fully. What the learned Attorney General, the then learned Attorney General said, is not something at variance, except one statement that Balsara need not be overruled. Otherwise, my Lord, the learned Attorney General also has said, my Lord, what we have respectfully submitted. But the question was, so I'm, my Lord, supporting synthetic too. But the question which was posed, my Lord, because of Mr. Datar's article, that executive estoppel. Lord, we have, if your lordships would like to go into it, we have already filed judgments. There are 4 judgments which takes the view that a separate view can be taken by the law officer, my Lord, because several things, my Lord, because of lapse of time, society may have changed, law may have changed, there may be several circumstances. There are 4 direct judgments. Now, would your lordships like to go into that question?
Yes, Mr. Ahmed.
Because I have emailed a short note, my lords, or I can hand over a hard copy. I have a few minutes, but I just thought yes, my lord, it's on the screen, my lord. Lord, my submissions in brief pertain to the meaning of intoxicating liquor in entry 8 list 2. And my lords, broadly, Justice Chagla's judgment in the Bombay High Court in Balsara, which has not been shown, and a few reasons why the Supreme Court decision in Balsara may not be correct. My lords, I highlight that is because the state's argument really to bring in non-portable into entry 8 hinges on the interpretation put forth in Balsara. So, my lords, only few submissions with respect to why Balsara may not be correct on the proposition 8 rule, my lords. Manoj, I will just very briefly go through these paragraphs, Manoj. First 3 paragraphs, Manoj, only highlight the fact that in entry 8, list 2, my lords, I'm reading para 2, my lords, the noun which is liquor is qualified by an adjective that is intoxicating. The plain meaning of the latter being of alcoholic drink or a drug that can cause somebody to lose control of their behavior or their physical and mental abilities. Manoj, this is a dictionary I've cited, and the antonym of which is non-intoxicating. That is, the consumption of the beverage does not lead to inebriation. And Malad, in paragraph 3, Malad, I've just highlighted that it makes no difference that the phrase meant for human consumption has been used instead and intoxicating has been done. And Malad, our understanding in Justice B.P. Jeevan Reddy's judgment, Malad, in para 4, I've just quoted the relevant para, Malad, to save time. This proposition is accepted, my lords. We'll just see para 10. I'll just read 2 lines in paragraph 10 of Bihar Distillery, my lords. It says, now coming to entry 8 in list 2, it does not use the expression alcoholic liquors for human consumption. It employs the expression intoxicating liquors, which expression is of course not qualified by the words human consumption. This is for the obvious reason that the word intoxicating signifies for human consumption, my lords. And that is, my lords, also, my learned Solicitor General has already dealt with Article 47, my lords. I've quoted that at the next page, my lords. The only reason I say that the same meaning which is there in Article 47 should be given. There's no reason why the same meaning should not be given. My lords, also, there are in paragraph 7, my lords, I have referred to the Constituent Assembly debates which were held on 24th November 1948. My lords, I've given the page reference. It was dealing with draft Article 38, my lords, which is now Article 47. And my lords, the whole discussion would show that it deals with intoxicating liquor, which is consumable as a beverage. And my lords, the importance there is they were dealing with this as a vice. They deal with all the religious minorities as to say everyone has a problem with alcohol spoiling a society, thereby showing it's purely consumable only, man. And Malad, I've just given the reference, Malad. Malad, now just very quickly to come to the decision in Balsara of Justice Chagla and the Bombay High Court, Malad, that has not been shown. I've just for Malad's convenience, I've quoted it here. Malad, I just wanted to say that the Balsara Bombay High Court judgment, Malad, dealt with the Bombay Prohibition Act. There was a writ filed to the Prohibition Commissioner, my lords, for certain directions. My lords would see para 11. My lords was dealing with entry 31 of the Government of India Act 1935, which is, my lord, the predecessor entry to entry 8. Maharaj, I would just like to read in para 12, I've quoted page 439 of the Bombay High Court Balsara, Maharaj. And this is important. We have next to consider the scope of the words intoxicating liquor. In the first instance, liquor ordinarily means a strong drink as opposed to a soft drink. But it must in any event be a beverage which is ordinarily drunk. In the second place, the use of the word intoxicating in item 31, in contradistinction to the use of the word alcoholic in item 40A, as qualifying the word liquor, is very significant. My lords, 40A is now entry 51 list 2. Reading further, my lords, we may also point out that the white paper item 26, which correspond to entry 31, use the word alcoholic liquors, which have in Government of India Act been changed to so and so. Therefore, it is apparent that the class of alcoholic drinks, non-intoxicating drinks, are excluded by this entry. Thirdly, medicinal and alcohol, which are found in entry 40C, are neither liquor nor intoxicating, and therefore they are obviously excluded from the scope of item 31. Malad, I will not read the rest of this. This deals with a judgment of the US Supreme Court in Selzman. Only to say the last bit, Justice Charla disagrees with the application of the US Supreme Court judgment, saying that only dealt with prohibition of noxious use. Because my note is only focused on the definition, my lord. My lord, now coming to the decision, para 13 onward, my lord, Bombay High Court came up on appeal to this court, my lord, where Justice Fazil Ali, my lord, disagreed with the view. My lord, just want to add one thing. Justice Chagla used the plain words used in entry 8. The Supreme Court Balsara decision, as my lord will see, gives no reason why we should give a go by to that plain meaning, my lord. Because the ratio in Supreme Court Balsara, my lord, is in paragraph 39, 41, 42, and 44. My lord, I've quoted it. I will not read the whole thing, my lord. I just wanted to say in para 39, this court summarizes what the High Court held, my lords. In para 41, which is important, my lords, they say, thus, according to the dictionary, the word liquor may have a general meaning in the sense of a liquid, or it may have a special meaning, which is the third meaning, fermentation or distillation. The latter is undoubtedly the popular and most widely accepted meaning, and the basic idea of beverage seems rather predominantly to run through the main provisions of the various acts of this country as well as of America and England relating to intoxicating liquor, to which our attention was drawn. I just want to pause here for a moment. Justice Fazil Ali does notice that this is the predominant understanding. However, further it says, my lords, but at the same time, on a reference to these very acts, it is difficult to hold that they deal exclusively with beverage and are not applicable to certain articles which are strictly speaking not beverages. A few instances will also make the point clear. In the national, this is of the US, this is called the Volstead Act, my lord. They had defined liquor and intoxicating. This portion is relevant in the National Prohibition Act, also known as the Volstead Act. The words liquor and intoxicating liquor are used as having the same meaning, and the definition state that these words shall be construed to include alcohol, brandy, whiskey, rum, gin, beer, ale, porter, and wine, and in addition thereto, any spirituous in malt or fermented liquor, liquids, and compounds, whether medicated, propriety patented or not, and by whatever name called, containing 1/2 of 1% or more of alcohol, my lords, will please mark, which are fit for use of beverage purposes. My lord, the Volstead Act, section 1, title 2 itself made it predicated on it being which are fit for use for beverage purposes. Having defined liquor and intoxicating liquor rather widely, the Volstead Act accepted denatured alcohol, medicinal preparations, toilet and antiseptic preparation, flavoring extracts and syrups, vinegar, and preserved sweet cider section for so and so. In some of these items, we have the qualifying words unfit for use for beverage purposes, but the heading of section 4 Volstead Act under which the acceptance are is exempted liquor. Well, I'll just very briefly, well, para 42 deals with the statute with the learned solicitor had shown. This is of UK. Justice Fazil Ali then gives the definition in 42. Manas 44 is important. 44, coming now to the various definitions given in the Indian Acts. I may refer in the first instance to the Bombay Akbari Act of 1878 as amended. Now, there are various statutes mentioned. I just want to point out these are all before the Government of India Act 1935. And then the portion after Bombay Act. Even if we exclude the American and English acts from our consideration, we find that all the provincial acts of this country have consistently included liquids containing alcohol in the definition of liquor and intoxicating liquor. The framers of the Government of India Act could not have been entirely ignorant of the accepted sense in which the word liquor has been used in the various excise acts of this country. And accordingly, I consider the appropriate conclusion to be that the word liquor covers not only those alcoholic liquids which are generally used for beverage purposes and produce intoxication, but also all liquids containing alcohol. It may be that the latter meaning is not the meaning which is attributed to the word liquor in common parlance, especially when that word is prefixed by the qualifying word intoxicating. But in my opinion, having regard to the numerous statutory definitions of that word, such a meaning could not have been intended to be excluded from the scope of the term intoxicating liquor as used in entry 31. My lord, in the next page, few paras, I have dealt with each of these paragraphs as to why Balsara Supreme Court has not applied the law correctly. I'll just very briefly, my lords, I have a few minutes, I think I'll just. My lords, para 14, my lords, my submission is, as is evident, Supreme Court Balsara does not provide any reason for discarding the plain meaning of intoxicating liquor in favor of contextually limited statutory definitions in colonial legislations passed prior to the Government of India Act and a few legislations. Well, just to summarize, Manoj, para 15, I say, when Justice Fazal Ali deals with the Indian Acts, in paragraph 16 and 17, Manoj, I've cited case law to say that a court should not interpret constitutional entries with the help of statutory definitions. For instance, my lords, in Ahmedabad Municipal, the meaning of lands and building and entry 49, my lords, was being considered. And this court said to look at the entries in the 7th schedule, because my lords, they are contextual, they are limited, and they deal only with the object of the statute. Similarly, in para 17, my lords, there's a constitution bench judgment which was dealing with the meaning of industry in section 2J. Again, my lords, while dealing with that, said you cannot look at the judgments or the meanings which have been given to industry to see entry 52 of list 1, my lord, because that is a more limited definition. My lords, I've quoted them, I won't read them, my lords, and I've given the page references. My lords, paragraph 18, my lords, I now deal with the foreign statutes which Justice Fazal Ali relied upon. And to say, even on a plain reading of those statutes, that conclusion could not have come, which has come in Balsara, my lord. Para 18, it is further submitted that SC Balsara's selective reliance on the definition of intoxicating liquor in the Licensing Consolidating Act was also incorrect. It did not consider the substantive provisions of the Licensing Consolidating Act 1910, which clearly indicate that an intoxicating liquor was nothing but a beverage, i.e., a substance actually meant for human consumption. My lord, in footnote 4, my lord, just for your convenience, I've mentioned all the sections. We'll have to clearly open.
Okay, very
Malad, Malad, in footnote 4, Malad, why I mentioned the National Licensing Consolidating Act 1910, why I mentioned, Malad had asked the learned solicitor when we were saying, Justice Fazalari notices the definition of intoxicating liquor in that. Apart from the fact, my lord, the judgment quotes a wrong definition. It's not in the statute, but my lords, I'm saying that statute substantively deals with beverages which are a substance meant for consumption. My lords, in the footnote, just for my lord's convenience, I've quoted all the relevant sections which clearly bring out that intoxicating liquor has to be a substance which is consumed as a beverage. I'm just saying, but with respect, Balsara Supreme Court did not see the whole act other than the definition, my lords. My lords, in paragraph 19, my lords, the learned solicitor has already dealt with these two, read the debates, my lord. So the law in England, which this court in Balsara dealt with, had a totally different view as to it had to be consumed. My lord, there are two new statutes which we were able to pull out. Para 21, my lord, I'll read. Similarly, the Intoxicating Liquor Act 1927 of Ireland considered intoxicating liquor as a beverage. Illustratively, in the enactment, it was stated that the expression on license
the word
very well,
intoxicating
Malad.
was common.
Malad, there is another interesting act we found in para 22, Malad, which is the Habitual Drunkards Act, Malad.
That's
Malad, I'll stop him. Malad, the only
Thank you.
Malad, just one last one. Synthetics, I would say. Sorry, I'm closing. Malad, synthetics. Preferred the view of Justice Chagla in Bombay in para 74. Malad, the reference order does not find fault in synthetics on this score of the disagreement with this court in view in Balsara, Malad. Just very grateful, Malad, for that.
Yes. To read that, this will Dunkard.
Malad, we found it only yesterday, Malad. I thought it was a very interesting
Not
statute.
amenable to any jurisdiction
Yes,
and lunacy. This is notwithstanding by reason of habitual intemperate drinking of intoxicating liquor, at times dangerous to himself or herself, or to others, or incapable of managing himself or herself and his or her affairs.
Malad, I found it very interesting.
By a person who was intoxicated.
In this definition, one need not be intoxicated also.
I'm very grateful, my lords.
Miss Taira Karanjawala.
May it please, my lord. Your lordships, I wish to address your lordships on the question of whether a notified order is required for a repugnancy to kick in under Article 254 of the Constitution. Your lordship, as far as this question is concerned, the first time these observations come into the jurisprudence is in Tikaramji. And as Justice Oak had observed, the actual question in Tikaramji was whether the UP Sugarcane Regulation of Supply and Purchase Act was repugnant to the IDRA. The Honorable Bench, having come to the conclusion that the State Act deals with the raw material concerned and doesn't deal with the product concerned, the raw material doesn't fall into the sweep of 18G, and therefore there is no repugnancy as the two acts operate in different fields. Of course, Learned Solicitor General has already addressed at length about how these observations are wrong. However, I'm on the second point of whether a notified order is required. Whether or not the first limb of the findings in Tikaramji is wrong or right, as far as the second limb is concerned, of whether a notified order is required, the Honorable Bench holds that even assuming sugarcane were an item falling within the sweep of 18G, there is no notified order and therefore there is no repugnancy. It is my humble submission that this was obiter dicta. This did not arise in the facts of that case, and therefore, and it is simply a three-line observation without any discussion on the implications of such a finding, on whether 18G was exhaustive in nature, although Tikaramji does notice the test of repugnancy, the three tests of repugnancy, in fact, including the test of whether the parliament has evinced an intention to cover the entire field. It does not apply this test as far as this question is concerned of whether the enactment of 18G itself is sufficient to denude the state legislatures, perhaps because it was not required to go that far, and the State Act was found to operate in a different field. Your Lordships, then in the 1990s, these same
Where does Tikaramji notice the threefold test of repugnancy? Can you just give us that para?
Yes.
Does refer
Yes,
to the
sir.
third. Occupied field, they refer to specifically.
Yes, Your Lordship. Your Lordship, the discussion starts at para 27, where it notices under the Australian Constitution,
Para 27.
para 27, Your Lordships.
All right.
Thereafter, Your Lordship, in the 1990s, two judgments, Indian Aluminium Company versus Karnataka State Board and SAIL versus Union of India, which have been cited by the learned petitioner, they follow these observations, again, without any discussion on the scope of 18G. And it's notable that in both these judgments, the State Act concerned had the assent of the President and therefore fell within the ambit of Article 254, Clause 2. And therefore, again, perhaps a detailed discussion on this aspect was not required.
Have you dealt with it in your notes?
Yes, in my note, I've emailed a note. Yes. Your Lordship, at page 10, paragraph I, at the bottom, in SAIL, para 2 and para 23-24, both notice that the State Act concerned had the assent of the President. Indian Aluminium Company also, at paragraph 12, the PDF pages are given in the note, notices that this particular, the state enactment concerned had the assent of the President.
Yes.
Therefore, again, there is no detailed discussion on this aspect. These observations are then picked up by the Constitution Bench in Bilson Sugar, and then further in ITC, and then has been cited as the continuing jurisprudence. And in fact, the reference order says that the bench in synthetics, which was a 7-judge bench, and Tikaram was a 5-judge bench, doesn't consider these observations, but actually these observations were purely in the nature of obiter dicta. As learned solicitor has already pointed out, 2 constitution benches thereafter have doubted this proposition of law in Tikaramji and has classified these as a misapprehension of the legal position, both in Chulak and in Maraprem. Your Lordship, as far as the test of repugnancy is concerned, from Tikaramji onwards to forum, there are 3 tests which have been recognized. Firstly, whether there is a direct collision between the Parliamentary Act and the State Act. The second, whether Parliament has enacted an exhaustive code or has evinced an intention to cover the entire field. And thirdly, whether the State Act has the State Act covers the same subject matter and seeks to set up a parallel mechanism as the Parliamentary Act. Your Lordship, in forum also, Your Lordships have given us guidance as to how one is to interpret test numbers 2 and 3. One of the tests that is given is the techniques used by the legislative draftsman, which include sections like whether the act is in addition to and not in derogation of. As learned solicitor already pointed out, section 31 of this act is unique because it only specifically says that that this act is in addition to and not in derogation of the central acts. The necessary implication being that it did intend to denude and derogate from any state enactments. In fact, the select committee on the bill specifically says that this clause was inserted ex abundante cautela to ensure that only the central acts were not derogated from. This is an important distinction from the decision in ITC, because in ITC, under the Tobacco Act, the relevant provision said that this act is in addition to and not in derogation of any other law for the timing in force. Our act, the IDRA, does not use the phrase any other law for the timing being in force. And it is my humble submission that this was an important consideration which should have been noted in Tika Ramji if the analysis was that 18G is not enough to oust the legislative competence of the states.
Well, it says that the application of other laws, which
Yes.
shall, the provisions of this act shall be in addition to and not save as expressly otherwise provided in derogation of any other
Central Act. It does not use any other law for the timing, Your Lordship. So therefore, the intention was to cover the field different from the decision in ITC. Your Lordship, then the second submission on 18G notified orders, Your Lordships, is that 18G is not a bald provision. 18G subclause 2 specifies different circumstances in which the central government can issue a notified order. For example, price control, regulation of distribution, transport, consumption, possession by use of permits, prohibiting withholding the sale of a particular article, reserving, directing that a particular product that is being manufactured only be sold to a particular person under certain circumstances. So therefore, it's my humble submission that enough guidance has been given in that section. Also, unlike certain other provisions in the IDRA itself, the notified order under 18G does not need any further approval or any other step by Parliament for it to come into force. There are other provisions in the IDRA.
Fundamental point is that that the doctrine of repugnancy in the sense of an occupied field is not dependent on the exercise of the power by
It's not dependent on the exercise of the power, and in fact, by the executive, because the test of repugnancy is a test of parliamentary intention. As far as
it's an occupation of the field by the legislature.
By the legislature. As far as Parliament is concerned, 18G is the last word, Your Lordship, because the provision is such that it is exhaustive for that particular time. It can't give any further details because the premise is that it will deal with a changing situation. And therefore, as far as the legislative and parliamentary intention is concerned, 18G is itself enough to oust the competence of the legislatures. And in fact, it may be distinguished from other provisions under the IDRA, where in fact, for certain delegated legislations, the government has to go back to Parliament. For example, where under 11B, subclause 3, in case the central government is laying down any conditions for a particular industrial undertaking to be considered a small scale undertaking, these requisites have to be laid before Parliament. If the management of a particular industrial undertaking is taken over and is extended beyond 5 years, that has to be laid before Parliament. And there are 4 such provisions in the IDRA itself. However, 18G doesn't require any further step by Parliament. And it's my humble submission that as far as the test of repugnancy is concerned, it is satisfied only by the enactment of 18G itself. Your Lordship, I'm very grateful for a patient hearing.
Your Lordships, my submissions have been emailed. If Your Lordships have my written submissions.
Yes, sir.
Your Lordships, I will argue on the first and the third test of repugnancy, Your Lordships. So far as third test of repugnancy, which is being on the same subject matter, Your Lordship's judgment in forum covers the subject, my lords. But my submission is that even so far as first test is concerned, which talks about direct collision, my lords. So here, there is a conscious legislative policy of not intervening in a certain manner, which learned solicitor said, forbearance. So the legislative tool, which legislative tool, how much has to be regulated, how pervasive has to be the regulation, at what periods the regulation has to exist, and when does it have to cease, my lords. These are all conscious legislative choices by the parliament. So we have seen the evolution of ID Act and the nature of regulation, the exemption. So it is a dynamic legislative choice which is being exercised by the parliament. So here, if the center is forbearing, not making a specific provision, not making a notified order, if the state, if that is considered to be unoccupied field by the state, then it is in direct collision with the conscious legislative choice of the parliament to abstain. Abstinence does not mean that I'm giving it up. I'm not exercising that choice.
which is there with me because I have spread my coverage to the entire spectrum, which is right from production to production, supply, distribution, raw material, right from raw material to production, supply, and distribution. So my legislative coverage is occupied, and it is my legislative choice to decide how much do I want to, how pervasive my regulation will be. So this, Your Lordship, it also meets the first test. Your Lordship,
Yes.
so Your Lordship, we can have my written submission, my para 2, Your Lordship. In the present case, Your Lordship, have my written submission.
Yes.
In the present case, the Parliament has legislatively covered the.
Just a minute.
The center is not issued.
That is also a choice.
That cannot be.
The second paragraph of my note. In the present case, Parliament has legislatively covered the field with regard to industries and production, supply and distribution of the products of such industries and their trade and commerce by means of RDI Act 1951. Section 2 read with 10, 11, 11B, 15, 16, 18G of IRDA in particular. It regulates not only the scheduled industries, but also the products of scheduled industries. That is to say, it covers all aspects of industries, right from procurement of raw material to trade and commerce in of the finished goods. While regulating, the Parliament sometimes makes a conscious choice of not intervening given the market conditions or other factors. It is a conscious legislative choice in the interest of development of scheduled industries or production, supply, and distribution or trade or
By
commerce.
regulating, when you said the Parliament makes a conscious choice, you mean the government, right?
Please, Manoj, yeah.
Government.
Please, Manoj.
The government sometimes makes a conscious
Yeah.
choice.
I'm sorry, Manoj.
Yeah, just go ahead.
It's a conscious legislative choice in the interest of development of a scheduled industry or production, supply, and distribution of products of the scheduled industry or its trade and commerce. Which legislative device or tool is to be used, how pervasive will be the regulation, and when it is to be regulated becomes the exclusive legislative choice of the Parliament once it has please, Manoj. Once it has spread its coverage to the scheduled industry, entry 52, list 1, and production and supply distribution of trade and commerce, which is relatable to 33. When there is a conscious exercise of legislative choice
of
forbearance, then intervention by state legislature is directly in conflict with the regulatory regime made by the Parliament by law, since industrial plan or scheme of the Parliament, where a scheduled industry or a class of scheduled industries or scheduled industries in general will be directly be hindered or obstructed by a state law. For example, if Parliament is of the view that a sector needs only light touch regulation or no regulatory intervention at all, or if the Parliament feels that an intervention will be counterproductive, the Parliament will abstain from providing any regulation and will allow the market forces to play. In such a situation, my lords, it may be read as government.
When you are emailing it Sanskriti
I will,
today, just correct.
I'll make correction.
You can say central government instead of Parliament.
Please, my lords. If such a situation, in such a situation, if state law is made, then whole policy of abstinence or forbearance is defeated, and such law will necessarily be repugnant in terms of Article 254, my lords. So what I'm trying to say is, my lords, even the first test of direct collusion is met, because here is a case of forbearance, and if the states start intervening because there is forbearance, it is defeating the policy of the central government, my lords. And my lords, on this aspect, judgment of innovative, my lords, 2018 1 SEC 407, please, my lords. Para 60, it says that the state law is defeating with the national plan and scheme of the IBC. So therefore, it was held to be repugnant. So, my lords, so far as second test is concerned, my lords, the same subject matter test is there, my lords. I just want to add, my lords. Here, my lords, often there are judgments where the inquiry diverts to how much is occupied and what remains. Instead of focusing on the same subject matter test, one gets into this test of how much remains, because that test applies for distributive list like entry 5423. So because there is a distribution of subject matter in list 1 and list 2, this examination may be necessary because how much field has been covered by the Parliament. But so far as the subject matter test, which is the third test, is concerned, my lords, this inquiry of micro dissection, whether this subject has been covered or not, that may not be a good test for 254, my lords, for the third test. And my lords, in this case, IDRA is a ragbag legislation, my lords. Entry 52, list 1, my lords.
It covers also entry 33 of this.
Entry 33, my lords, your lordship saw price control also, which is entry 34, my lords. Prior to 2017, there was taxing provision also. So 84. So this ragbag legislation has too many rags, my lords. It's a comprehensive legislation. So that has to be kept in view while a state law is being seen, my lords. And my lords, the test in Tikaram which says occupied in fact, not mere possibility, my lords. The test is correct, but the application of test is incorrect. Occupied in fact only means Parliament has in fact made a law. There is no possibility of making a law. So if there is a law, the test is complete, my lords. And my lords, for the third test, my lords, there are two other aspects. If your lordships come to para 3 of my note at page 5, at page 3, my lords. Roman 3 and Roman 4. The Parliament may envisage a national level policy and a parallel law by state legislature cannot be
That was
permitted.
innovative, the
Please, my lord.
IBC case.
And my lords, the fourth aspect is aspect of uniformity. My lords, a concurrent list has those subjects where uniformity may not be mandatory like list 1, but desirable. So when Parliament makes a law, keeping the intention of having a uniform law for the entire nation is concerned, my lord, then variations by the state, my lords, they will have to be read with lot of circumspection, my lords. And my lords, para 5 of my note, my lords. It is submitted that the most vital subject fields which could not have been left to the state provinces and were all India import were put in list 1. These are subjects where uniformity was imperative and there was no room for any variation as per state needs unless entry itself provided for that. Those subjects where uniformity was desirable with room for variation or modification by legislation for states, if need be, were put in list 3. This is also reflected from the Constituent Assembly debates dated 4th November 1948 when the draft constitution was being discussed. Dr. Ambedkar said there is another special feature of the proposed Indian Federation which distinguishes it from other federations. A federation being a dual polity based on divided authority with separate legislative, executive, and judicial powers for each of the polities is bound to produce diversity in laws and administration and in judicial protection. Up to a certain point, this diversity does not matter. It may be welcomed as being an attempt to accommodate the powers of government to local needs and local circumstances. But this very diversity, when it goes beyond a certain point, is capable of producing chaos and has produced chaos in many federal states. One has only to imagine 20 different laws. If we have 20 states in the union of marriage, divorce, of inheritance, of property, family relations, contract, torts, crimes, weights and measurement of bills and checks, such, Mamalos, I will give that, and such a state of affairs not only weakens the state but becomes intolerant to the citizens who moves from state to state only to find what is lawful in one state is not lawful in another. The second paragraph, Mamalos, care is taken to eliminate all diversity from laws which are at the basis of civic and corporate life. The great codes of civil and criminal laws such as CPC, Penal Code, CRPC, and the Evidence Act. Mamalos, I will not read any further. Only the last 2 lines, so that necessary uniformity can always be preserved without impairing the federal system, my lords. So, my lords, uniformity is one factor which is relevant while applying the third test, my lords. Para 6 subjects such as criminal law, criminal procedure, marriage, divorce, adoption, transfer of property, contracts, bankruptcy and insolvency, prevention of cruelty to animals, legal and medical and other professions are few such illustrations wherein a uniform law has been laid down by the parliament. These laws do no doubt do have certain state amendments, but Article 254(2) specifically takes care of such a situation wherein variation, modification, which are required, are, my lords, assent can be taken by the president, my lords.
Thank you, Sanskriti.
I'm obliged to this.
So we'll give you 10 minutes.
Chiefs have been very kind, my lord. I'm really great.
Thank you. No, thank you. All of you, Omar, Sanskriti, and Taira. Thank you very much. So we now have 1 hour is too much. I'll tell you why. Our schedule is we have to wrap up by lunch on Thursday, both sides. So we'll have to give them 2 hours. We will have to wrap up by lunch on Thursday, so we'll have to give them time to make their rejoinder.
That may not be viable with you, sir. By lunch, I cannot, perhaps I'll try my best, but it's not.
But now we have seen, you have to now make your.
The response may take time, no?
We'll
As
be
I said,
precise.
I think we have, what we
sitting in
suggest, what we suggest is
every day.
that you circulate your
I have already filed my written submissions,
Alright.
but I'll take at least 45 minutes, if not an hour.
We read your submissions.
Yes.
We read your submissions.
Yes.
We'll give you 10 minutes and 10 minutes to.
My lords, 10 minutes would not be sufficient. My lords, just a minute. My lords, 10 minutes would not be sufficient because I am representing the industry and industry is the,
That's all right.
the receiving end.
I know, but this is
Because,
the general.
no, I know, my lords. My lords, at least 45 minutes I will
We
require.
can't do 45 minutes, absolutely. We have to,
My lords.
look, we will give them, I'll tell you what we'll do is, we will give them 2 hours for the rejoinder. 2 hours for the rejoinder is very fair for them. So 11 o'clock to 1 o'clock, we'll give them for the.
My lords, half an hour would be too.
So.
My lords, if
Then
I
what we'll do is we'll give them 2.5 hours for the rejoinder. We are our conscience is satisfied. We have heard you all sufficiently. So half an hour between all of you, 10:30 to 11. 11 to 1 is the rejoinder, and we could wrap up. One rejoinder, no, not more than one rejoinder. I think we have to, all things have to end.
They have agreed not for one rejoinder, Mr.
Yeah.
Vivid is giving that.
Yes.
Okay.
वीर सपूत का स्वागत करें। अपने भाजपा के जिला अध्यक्ष संत चिंटू जी से आग्रह है कि मंच पर अपने प्रधानमंत्री मां भारती के सपूत का स्वागत करें और उन्होंने तिलकुट के लिए जो जीटी एक्ट दिया है उसके लिए भी उनका स्वागत, अभिनंदन, वंदन चांदी के तिलकुट से करें। अब हम अपनी नारी शक्ति, हम लोग अपनी नारी शक्ति नीमा देवी, ललिता देवी, प्रीति जी और सोनी जी से आप विनम्र निवेदन है कि भारत मां के सपूत प्रधानमंत्री नरेंद्र मोदी जी का स्वागत करें। श्री कृष्ण कुमार सिंह जी से आग्रह है कि मां भारती के सपूत प्रधानमंत्री नरेंद्र मोदी जी का स्वागत करें। अब आग्रह कीजिए विजय सिन्हा जी से वो आए। स्वागत तो करें। हम लोगों के जाने माने उप मुख्यमंत्री बिहार सरकार